Matter number 1 and 2. फोन करेंगे फोन करके क्या वो करेंगे
Affidavit not filed?
Lordship, may I please, Lordship? Lordship, on behalf of Tijamo, Lordship. Lordship, he's out of station, Lordship.
Out of state.
Out of station. Lordship, we'll file affidavit, Lordship, in position of Himalayan University.
May I please, Your
4
Lordship?
and 5? For, on behalf of
1, 3, 4.
1, 3 and 4.
1, 3, and 4.
Yes.
Your Lordship, in item number 2, since April 2024, the matter is pending for filing of opposition, Your Lordship. Affidavit in opposition.
April 2024.
Yes.
Last month.
Oh, yes, 23, Your Lordship.
23.
Yes, Your Lordship. So, Your Lordship, maybe they were not interested to file the affidavit.
1 year,
They-
1 year.
Yes, Your Lordship.
Same parties.
No, I am for the petitioner.
My lord, so far respondent number 2 is concerned, my lord, we'll go by the affidavit filed by the respondent 1, 3, and 3, 4, 5, my lord. Then, if your lordship peruse, my lord, last time on by order date 24.
But you have not filed. 1, 3 and 4. They have not filed affidavit. 1 and 3. 1 and 3 has not filed
But
affidavit.
issue is same.
Ah,
I think the affidavit file in another writ petition, I think that will suffice, that will cover, I
you are
think.
for 1 and 3?
Lordship, in
Item
I-
number 2?
item number 2,
Ah,
1, 3, and 4, Lordship.
3 and 4.
And in item number 1, Lordship,
So why are you taking such a long
1
time
and 3, Lordship.
to file affidavit?
Lordship,
Today he is not well, maybe out of station, but
Lordship.
for 1 year,
Lordship, actually,
yeah, I think for 1 year, why you are taking such a long time? 7/5/24, yes, it was obviously. Have you filed affidavit, no?
Lordship, actually, we have filed the affidavit of opposition in item number 1, Lordship. So, Lordship, in previous occasion, we have advised this honorable court that we'll go with this. But
That affidavit of item number 1 will suffice
Lordship,
for item number
same
2.
matter has been challenged.
You have filed affidavit in opposition
Lordship,
for item number 1.
item number 1, Lordship.
So this will suffice.
Lordship.
Okay.
Your Lordship, in the item number 1, the petitioner has made income, good and service tax council as a respondent number 5, Your Lordship. But in item number 2, we haven't made the party to the good and good and service tax council.
Yes.
That's the thing, Your Lordship. Different system.
Are you not filing affidavit in item 1?
In item number 1, I am for the respondent number
4 and 5. Yes.
Our affidavit might not be required because, my lord, this is the policy decision of the state government to regulate, my lord, how the fees will be fixed.
Not required.
To be recorded.
Basically, we don't have any much role in the fixation of the fees.
You see, I think they do filing,
Yeah.
because they file an item.
And item 1 they have filed.
Yeah.
Okay.
It will cover. He's saying that we will talk about it, but they won't do it.
Proceed for admission. So we'll proceed for admission then.
On the next stage, Your Lordship, is my seniors come from Guwahati.
Hmm?
My senior is come from Guwahati. That's why, Your Lordship. Next thing on the
Your senior
fix
from
on
what?
admission on hearing.
I'm supposed to fix the date on the next date.
What is the ground of challenge?
Actually, Your Lordship, ground of challenge was that, in regard to the 1%, which was
Yes, are you
imposed.
saying is it is the state is incompetent to enact a law to levy a 1% fee?
In that ground only, we are challenging Your Lordship.
If they are competent, nothing.
Yes.
I think that is the simple issue.
Yes.
On
If
what
only-
ground you are challenging it?
So in item number 1, who is for state of Arunachal Pradesh?
My lord, I am my lord.
1, 2, and 3.
No, my lord, only two, my lord.
Only 2.
Only two. Item number 1, only two. That is the secretary. Yes, my lord. Secretary.
Education Department,
I'm sorry, my lord.
you have filed affidavit.
Well, only ground is that there is no quid pro quo, my lord.
Hmm.
Saying that this autonomous body, they are not providing any service, but they are charging the tax. That is the only issue, my lord. There is no quid pro quo.
How can then claim a quid pro quo? Quid pro quo is impermissible.
So you won't file affidavit in item number 1?
No, my lord, the affidavit filed by the, my lord, this autonomous
Will
body, that will
suffice.
suffice, my lord. Then another issue, my lord, since they have challenged the act, the Honorable Court has issued notice to the Learned Advocate General, my lord. If you lordship peruse the order 24/4/2023, yes.
Advocate General has to reply because it is an act.
Once notice is reached to him, my lord, it's up to
Notice has been issued,
long
Why?
time back, my lord, 24/4/2023, my lord,
but
yes.
he has not submitted any.
My lord, I am not aware whether my lord he has received the notice or not, my lord. I am not aware of that.
I'll check just.
You
let me check.
ask your junior
Which
to
item number?
apprise him.
Both, my lord.
Both the items.
Yes, my lord. It's an analogous matter, my lord.
Yes, it's an act, so
Since they have challenged the act itself.
correctly issued a notice. So this,
Anyway, my lord, will inform the Learned Advocate
You
General.
ask your junior to inform him
My lord.
on the next date.
departmental. All right, we'll keep this matter for orders only then.
My lord, yes.
Hmm?
My lord.
Advocate General has to appear. Can you give me the date of the order when the order was passed? for the
Order
Advocate
dated, my
General
lord,
to appear?
24/4/2023. My lord, I am informed by senior government advocate, the Learned Advocate General will be available on 6 June, my lord. He's coming on 6
On
June.
6 June.
Can it be fixed up 6 June? Well,
Had Miss
C. Earing.
Learned Counsel for the petitioner, comma, Mr. For, yes, your name, good name, please. For Learned Counsel for the respondent number 1.
1, 3, and 4 in item number 2.
Item, no, I'm taking up the item number 1.
1 and 3, Lord.
1 and 3.
One
For
and
the
three.
respondent number 1 and 3. And you are?
my
DA,
lord, no, I for respondent 2, my lord.
Respondent
Addition.
education.
Yes, my lord. Both the items.
Additional advocate general.
And learned T. Jammu,
No, RS Nabum, my lord.
RS,
RS Nabum, my lord.
Navam, double AG. And Mr. M. Kato
For respondent number 4 and 5.
for respondent number 4 and 5. This is item number 1.
1.
These
In item number we are not 2. We are not.
And learned DSJI, Mr. T. Kato for respondent number
4 and 5.
4 and 5.
M Kato, M Kato.
M. Kato. While order details.
9
24, no? This is item number 1.
Yes.
Okay. 9-2.
That notice to the advocate general. of the
Okay,
state.
by order dated 9/2/2023, notices were issued to the Advocate General. It is submitted that notices were issued as this is the matter on,
6th June, my lord.
Ah.
6th June.
this is the matter on 6th June. Item number 2, Miss A is our petitioner. And in item number 2, you have response number 1.
I think item number two, Lordship, 1, 3, and 4.
Response number Mr. S. Erin.
K Tabang, Lordship,
K
on
Tabang.
behalf of T Jabang.
Oh, you were Erin
Yes.
for a 1 3
4.
he wasn't it? And Mr.
Same, my lord, response number 2, my lord.
2, respondent number 2. And Mr. You are not appearing in this case.
Nothing.
By the order dated, this is on 24/3, na? When was this order?
This was.
The learned advocate general notices,
24/4/2023, my lord.
notices were issued on 24/3/2023 for the presence of learned advocate general. List the matter on
6th May.
6th May. No, item number 2 लिखिबा.
I'm sorry, 6th June, my lord.
6th June.
6th June.
Item number 2 लिखिबा. The learned counsel for the respondent number 2, 4 and
1, 3, and 4.
1, 3 and 4 has submitted that affidavit in opposition has been filed in in the WPC number, which is
476.
476.
WPC number 476, which can be taken up along with this petition conjointly. Full stop. And you all will not file affidavit in opposition.
No, my lord, we will not file, my lord. We will rely on the affidavit filed by the respondent number 1, my lord.
The other respondents will rely on the affidavit filed with the respondent number 1.
Your Lordship, copy may be served.
This was on 24/4.
24/4 day, 24/3 nothing. Advocate General, see. Advocate General APD, Arunachal Pradesh लिखेगा.
Item number 3.
It's 1 and 2. Service report on respondent number 3 and 4 is awaited. List the matter on, when do you want?
Whenever, no fixed date is required.
After 2 weeks? Beginning of তাৰ আগতে লিখি দিবা office note dated 7/5/2024. Mr. M. Kato, learned DSGI is present on behalf of respondent number 1.
1 and 2.
1 and 2. Miss,
Tirimi,
এইটো পাছত উল্টাকে লিখি দিবা আগতে মিস লিখিবা তাৰপিছত এওক লিখিবা ৰেসপন্ডেন্ট আৰু বিগিনিঙত তাৰপিছত লিখিবা অফিস নোট ডেটেড
Lase.
2 weeks.
4 and 5.
Marvelous, ma'am. My lord, here in this IA, I have limited prayer that there is a minor mistake in the pleading to be corrected, particularly in page number 3 and the prayer portion. That limited prayer is only limited prayer is being sought from this honorable court. My lord, may kindly come to the page number 4, paragraph 4. Here I have explained the which portion I need to correct it. In the course title, I wanted to put the public interest litigation against the Department of Town Planning and the Urban Local Bodies, Government of Arunachal Pradesh. And thereafter in page, in prayer portion, as to why the direction shall not be made to the Chief Secretary to the state to forwarding the allegation of the payment of 14 and 15 Finance Commission to SIC of the state to holding the inquiry of the case. This must only that my
Where is
prayer
the
in
prayer?
this case.
Paragraph 4 of the IA.
my lord.
Prayer, where is your prayer? Paragraph
Pray-
4 of the IA. Not prayer, no, where is your ground? Paragraph 4 of the IA. Which
My
paragraph?
prayer in,
No, not prayer.
next,
Ground,
next.
ground. I'm asking about the ground. You have file an IA.
Yes. That's, there is no other ground, my lord. What I filed that these need to be inserted. These certain word need to be inserted in my pleading. And basically, this objection was raised by the respondent number 2 and 5 on the many occasions. That
That's the reason.
He is not filed the objection. He is not present also.
so in the so far the last
I thought he
okay,
is the respondent.
State.
if I'm not mistaken, my lord, so far I remember in the last occasion, the rest has no objection.
Yeah,
But the-
he is conversant with this case because he was present in the last case.
yes, the objection was from the respondent 2 and 5.
Yeah.
In
amendment
such situation, let the matter be arranged posted for tomorrow.
Tomorrow,
so that-
yes, can be held.
My lord,
Why to file an objection for an amendment?
no, I don't want to file any
No,
objection,
you are
but
not supposed to file.
but
I
the
think some
very-
other respondent.
yes, but the very nature of the prayer is that he wants to replace the pages in the PIL. He doesn't want to file a consolidated amendment petition. my lord. The prayer is such that if my lord sees,
Is it an amendment or replacing?
Replace.
So you file a fresh petition in that case.
that's why.
You have filed
I
for
cannot see any
My
ground
lord,
in the
my lord,
petition.
that is the, in such situation, my lord,
I'm asking for the ground. I cannot find any ground in the
Fine.
petition, in fact.
my lord, I am admitted, my lord, there is no other ground. But this is because of the respondent number 4 and 5, who has objected in such a minor that they are in cause title, they
Okay,
have
so
not
it's-
been inserted. That
There's
that
already
only.
an order passed for
I
objection,
think
so
it
we
will
wait
be
for the objection.
convenient for him if he withdraws and files a fresh
Yes, yes.
petition.
I think so.
Otherwise, replacing cannot be permitted, my lord.
Why, my lord, replacing is asking for? Because, my lord, I am to correct that page number 1 to 7 and thereafter 46 page number only. Therefore, I am confined with this particular page. So let the objected
See, there is a huge difference of amendment, replacement.
my lord. In fact, I am seeking from this honorable court for minor correction.
Tell us how the amendment is allowed. Amendment to the petition is allowed. Plaintiff is allowed.
My lord, that is there when, my lord, there is a major defect and when,
I think it's better you withdraw and file a fresh petition. It's better.
my lord, in such situation, let the IAB, my lord, dispose of.
You have
but-
filed an application for amendment,
my lord.
seeking amendment, and you are making a submission for replacement, which may entirely change the.
Exactly, my lord, there is. But what I am, my lord, trying to point out is that I have limited portion of the page to be corrected. In fact, this is also because of the respondent number 2 and the 5, which is not very major issue. But since I have taken the consent from this court to file a fresh IA for correction, therefore this IA is being placed.
This is not for correction. This is for amendment. Your IA is for amendment.
My lord, amendment to course title.
Goes from page 1 to 7 and page number 46 of the PI.
Exactly, my lord.
Because this the page 46 is prayer portion. That will entirely change.
And my
which
lord,
for which the amendment cannot be allowed.
my lord. Therefore, my lord, I have been added in, I have described in para 4 what word I wanted to be inserted. Particularly this hardly 4th hardly 3 to 4 sentence only.
One word may also change the petition.
So, my lord, may I suggest that let the council who is objecting on the amendment be appear?
No, we're not interested if he's not there. You satisfy us whether it can be amendment can be allowed or not. Obviously, you are not making a submission, making argument on amendment.
My lord,
You want that
I'm
it should be
admitted.
replaced.
my lord.
Replacing may not be permissible.
All right, let
Madam,
us
there is
fix
no
it for,
provision for
let
replacing.
the other respondent come.
My lord, there is no
the
provision
basis
for
of it.
replacing pages in the petition, my lord.
You're right, but let the,
Amendment can be possible if he files after being allowed, he files a consolidated amendment petition. But replacing the very
Particular.
original petition, that cannot be allowed.
what about T Omo? Let him
Madam-
come or we'll fix a date, then whatever order required to be passed can be passed. And if on that day he doesn't come, then we can dispose it off.
No, in any case, whether he makes any, Mr. Omo makes any objection or not,
I understand, but
whether
I'm
this
reserving my comments
I-
on that.
I can be allowed with this prayer. Madam. Prayer is to kindly insert and amend in concerned page of the petition of.
If that person doesn't come, you are not going to
Finally, my lord,
Hmm.
I have decided. Now I got the problem. So I may be able to withdraw this.
Withdraw the
I-
I, of course.
I-
You won't withdraw the petition, I understand.
Yes,
Withdraw the I.
yes, yes.
All right then.
It need to do some correction.
Four and five.
I am for the
Only
petition.
four, not five. For four, Lika. Learned Counsel Mr. C. Modi is present on behalf of the petitioner and he has prayed for withdrawal of the interlocutory application. Mr. N. Ratan,
Yes,
learned government advocate is present. Uh, Government advocate from Arunachal Pradesh is present. He has no objection. Oh, additional AG, yeah. Additional AG is present. Additional AG of Arunachal Pradesh. And he has no objection on the prayer submitted for withdrawal of the petition.
Not my lord, sorry for interruption, not petition, my lord.
interrupted.
I number 58.
Yes, yes. Thank you for correcting me. Application, interlocutory application. The I is dismissed
On with
on withdrawal, matter is closed.
obvious.
And what about this WPC?
After
List the matter after 2 weeks?
2 weeks.
WPC to Likiriba, presence to Diriba, list the matter after 2 weeks. We have a hearing. Everybody's ready.
Item number 6.
Your Lordship,
Mm.
for the appellant, Your Lordship.
Are you ready? Okay, then we can proceed.
Your Lordship, this appeal has been preferred against the judgment and order dated 33/22 passed by the learned session judge Khonsa, Your Lordship, thereby convicting the appellant under section 302 IPC, Your Lordship.
302.
IPC. So by the same judgment, Your Lordship, the other two accused were acquitted, Your Lordship.
Mm.
The relevant portion, the operative portion is at page 120, Your Lordship, which is the operative part of that order.
Page 120.
120 of the paper book, Your Lordship.
Yes. Yes.
Yes, Your Lordship.
Mm.
Para 86, Your Lordship. From the discussion and foregoing decisions arrived at, it is found that the prosecution has proved it beyond reasonable doubt that accused Ram Ghimire has committed murder of Ontilu Tikhak, thereby committed an offense punishable under section 302 IPC. However, prosecution had failed to prove it beyond reasonable doubt that accused to Usha Ghimire and Deepa Ghimire has committed any offense. Accordingly, accused Ram Ghimire is convicted under section 302 IPC for commission of murder. Usha Ghimire and Deepa Ghimire are acquitted from this case and they are set in liberty. Now, Your Lordship, sentence part is at 89.
You have the LCR with you? LCR?
Yes, Your Lordship, we have got the paper book also.
We don't have the LCR, no? LCR?
Must be.
Your Lordship, the sentence part is at para 89, Your Lordship. And that is Ram Ghimire is convicted for the offense of murder under section 302 IPC. He is sentenced to undergo life imprisonment and pay a fine of rupees 20,000 for the offense of murder under section 302 IPC, which this court considers will meet the ends of justice. In default of payment of fine, the convict is to undergo further simple imprisonment of 2 months. During investigation, convict Ram Ghimire was detained in custody for 96 days, as such as provided under section 428 CRPC. Custodial detention undergone by the convict during investigation of the case be set off from the quantum of sentence to be undergone by him. So that has been set off, Your Lordship. Your Lordship, the instant case was initiated with an FIR, Your Lordship, which has been lodged by one Meghnad Kaur. And that FIR is at page 1 of the paper book. In that FIR, that the informant stated that while he was coming from the grazing field, he saw a lady lying in pool of blood with her slitted throat. Accordingly, based on that FIR, Your Lordship, a case was registered, inquest was done, Your Lordship, and the body of the deceased was identified by the husband of the deceased. Inquest report is at page 19 of the paper book, Your Lordship. So body was identified to be that of let Ontilu Tikhak, Your Lordship. Thereafter, Your Lordship, during the course of investigation, disclosure was made by the son of the deceased, Your Lordship, which and on the basis of that disclosure, Your Lordship, these the appellant and the other accused were arrested. This disclosure, Your Lordship, would find at page 20.
Page 20?
Page 20 of paper book. From this statement, they came into picture, the appellant and other accused. That is, the statement is here. On that day in the morning at school time, my mother and me came out together from our house. On the way from market, my mother purchased 2 packets of biscuit, which she carried with her to the house of Ghimire by Ram Ghimire, that is appellant. From road, I saw my mother and wife of Ghimire were talking, and from this, I went to my school. From that onwards, I did not see my mother again. Next day only, I came to know that Ghimire Bai killed my mother. The above is the true interpretation of the deposition and all.
Now, your lordship, during further investigation, they, after their arrest, their confessional statement were procured, your lordship, which your lordship could find at page 32. 32 is the confessional statement of the appellant herein. Page 32.
Yes,
Your lordship, I will go through this confessional part here.
yes.
I am here at Meow from 1991 onwards. Page 32, your lordship.
13,
32, your lordship.
32.
Yeah, yes, your lordship.
Yes.
I am here at Meow from 1991 onwards under APSTC, serving as a driver. I have two children, one daughter and one son. However, daughter of my wife's sister is also staying with me from her childhood. Let Ongtilu Tikhak was known to from 1991 to 92 onwards when she was studying in HS school, Meow. Her husband Lama is also known to me from last 10-12 years. 4 or 5 months ago, probably during the month of January 2004, she met me at Meow Market and invited to her house near Forest Colony, Meow. For the first time, I came to his house, and from that day onwards, I was a frequent visitor. We had also physical relation during the month of May 2004 on my Mrs. Asa Ghimire, my Mrs. Usa Ghimire came to know about our relation and for which she abused me and the lady for several times. On 27/7/2004, when I reached Meow from Dibrugarh at about 1700 hours, let Ongtilu Tikhak was in our government quarter and was fully under the influence of alcohol and was shouting that she will take me with her and will kill my wife and children. At this, I instructed my wife and daughter to take her out from our quarter and keep her near the jungle area. I followed them, and in between cooperative store and Sri Gumjanong residence, I asked my wife and daughter to return back to our quarter. From there, I accompanied with Mrs. Ongtilu Tikhak to the old mill building, which is situated about 100 meters away from Sri Gumjanong Singpho's residence. She was at that moment not in sense, and I, with my dao sword, which I brought with me from my quarter, slit her throat with that dao, where she breathed her last. The above examination was taken in my presence and contains a full and true account of the statement made by Kisram. This is the confessional statement of the appellant. And 34 is the confessional statement of the other accused who were acquitted, your lordship. That is also relevant to your lordship. 34, next page is 35 is the contents of the statement. On that day, let Mrs. Ongtilu Tikhak came to our house at about 1000 hour. She came alone and brought with her one bottle IMFL liquor. That day she came in a very angry mood and asked about my husband Sri Ram Ghimire as she had some discussion with him. At that time my husband was not in residence as he left for his duty. She started arguing with me and said that she will marry my husband and will stay with him. She also threatened to kill all our family members. She started drinking the IMFL which she brought with her and remained in our house for the whole day. In the evening, when my husband returned, he also tried to persuade her, agreed to pay some money also. Though at that time she was arguing with my husband, she was not in full sense. As desired by my husband, I, along with my daughter, Miss Deepa Ghimire, took her out from our house, and I know nothing about her mother.
So three accused have all confessed.
Only three accused
Statement of
confessed.
Three accused have been
Yes.
recorded.
This is second accused, that is the wife of the appellant. And the 37 is
So
the,
this is not confessional statement by the
this
way.
is
35.
exculpatory. All. Yeah.
35 is not confessional statement.
So they are only stating,
All right, you can proceed.
okay, the 37 is this daughter's confessional statement. On that day in the morning at about 900 hours, I came out from our house. At the time of my departure, let Ongtilu Tikhak was not there in our house. She came after my departure only. When I reached back at about 1400 hours, I saw my mother and let Ongtilu Tikhak were discussing and some arguments were also there.
Okay, I'm ready.
So now, your lordship, this charge sheet was laid under section 302, 201 and 34 of IPC, your lordship. And the charges were also framed on that sections only. During the course of trial, the prosecution examined as many as 9 witnesses, your lordship. The first witness, your lordship, would find at page 52, your lordship. PW1, that is the husband of the deceased, your lordship. Page number 52.
Yes.
Chief, your lordship, Ongtilu Tikhak was my wife. I have 3 children born from her. I am looking children after the death of my wife. On that day, my wife had taken my son to the school, and I also went out for duty. My son asked his mother for purchasing some sweets from shop, which she did, and they were proceeding towards school via the house of Ram Ghimire. Daughter of Ram Ghimire came out of the house and informed Mrs. Tikhak that her mother, Usha Ghimire, was calling her to come. Then Mrs. Tikhak replied she would come after dropping her son at the school. While returning from the school, she had gone to the house of Mr. Ram Ghimire, and thereafter her whereabouts was not known. After coming back from duties in the evening, I with my children searched all out for her but not found. Next morning, I was informed by police that she had been murdered by somebody and her dead body was found lying in the jungle. Cross is on the next page, your lordship. 53. I did not see whether my wife had entered the house of Ram Ghimire while returning from school. Even my son did not inform me that he had seen her entering the house of Ram Ghimire. The next morning, police informed me about the incident and repeatedly asked if I have killed her. Police went took my statement, showed Mr. Ram Ghimire and asked me if you have any doubts about the involvement of the person, which I replied in affirmative. My doubts on him was due to his frequent visit to my house. Other than Ram Ghimire, many other person and my relatives also used to visit my house. It is not a fact that I had stated before the police involvement of any other person other than Ram Ghimire. It is not a fact that I stated before the police regarding involvement of the accused for fear of the police. Now, he has again been re-examined, your lordship, that your lordship would find at page 54, your lordship. On 7th day of June 2016, he was re-examined. It was with regard to exhibit. P exhibit 1A is my signature. I can identify my signature in the inquest report. I have seen the police doing formalities on the dead body of my wife at Sawmill. It is fact that I have put my P exhibit 1 signature at police station and not at Sawmill. I don't know why my signature was taken in that paper. I don't know the contents of the document, nor I was read over by the police. So, your lordship, by going through the evidence of PW1, it appears that he is not a direct evidence, but hearsay, your lordship. He is stating whatever he has heard from his son.
He was the prime suspect.
Yes.
Being the husband, he was the prime suspect.
He was the prime suspect. Now, coming to the deposition of PW2, which your lordship would find at page 55. Your lordship should have proceeded. Sometime I'm escorted. He is the son of the deceased. Sometime I'm escorted by my mother to the school. On that day, we met the daughter of Ram Ghimire on the way to the school. I know their quarter at Miao and also know her because she once came to our house to call my mother. My mother talks to Ghimire's daughter, but I did not hear their talking. Mother purchased some biscuits from a shop and had taken to Ghimire's house. I overheard saying my mother to Ghimire's daughter that she would come to their house after dropping him in the school. When I returned from school, I did not find my mother at home and my father, and we all started searching to find out her whereabouts. Cross, it is a fact that I am not seen her going to my place after dropping me in the school. Also that when I came back to home after the class are over, I did not find her at home. Now, your lordship, here from the statement of PW2, it is also not clear he did not see whether the deceased went to the house of Ram Ghimire or not.
So we have only 3 main basic evidence: the eyewitness, not the eyewitness, that
this
the
confessional statement has been
and
heavily relied on.
and this witness last seen.
Yes.
And almost last scene, not last scene.
But not
Alright.
together with the, because appellant is not anywhere near to the deceased by the statement of PW. Now, PW3 is some Hiralal Day. That is page 56, your lordship. I can recognize two of the accused person, Ram Ghimire and Usha Ghimire, who are standing on dock.
It's not required. I'm just had a
Yes.
glance over it.
Yes, sir.
I think the other statements are not required. to
PW4
be-
are the photographs who took the photographs of the
not required.
deceased. Now, PW5 is. She is also a hearsay evidence, your lordship. I know the accused person is standing on the dock. She is wife of Ghimire. I came to know about her this morning only. This is Rongtilu Tikhak was my daughter-in-law. My daughter-in-law is no more. I heard that one morning the daughter of the accused came to the house of deceased and took her to somewhere from where she never returned. Dead body of deceased recovered from the bank of River Dean. I, on being informed by the police, brought the dead body to hospital and then to my house. In the course of investigation, the accused person were arrested by police. At the time of incident, I was
Not required,
not recorded. Now, PW6, your lordship.
This is not required.
That is also not recorded.
You can read the doctor's evidence.
Doctor's evidence here. PW7, this is at
Only the opinion and
63 is
only the findings.
findings here. That is at third para of page 63. In my opinion, the cause of death was due to massive hemorrhage and brain anoxia due to the main carotid artery and veins which supplies blood to the brain were severe. The nature of injury leads to sudden cardiorespiratory arrest and cause immediate death. Death was homicidal in nature. As per requisition of IO, I have prepared the PME report of dead body and handed over the same to IO. Exhibit 3 is the PME report, 4 and 5 are the dead bodies. It is a fact that I have not written in the report that the injuries are antemortem or postmortem. I have not mentioned that time since death of the dead body. I have not mentioned that exact size of cut injury. I did not mention from which side the cut injury was inflicted, but it was a sharp cut. The time for PME takes 1 to 2 hours, depending upon the nature of death. The PME of the dead body took about 35 minutes. I need at least half an hour for preparation during PME. I have not mentioned in the PME report as to whether the injury was suicidal or homicidal in nature. So, your lordship,
She has mentioned homicidal in nature.
in chief, she has mentioned, but in the
But
report,
not in the report.
in the report, it has not been mentioned, which has been explained. Now, this is PW8, who is the magistrate, your lordship, who took the confessional statement. Your lordship, on 3/8/2004, I was posted at Miao as EAC cum JMFC. On that day, one accused person, namely Ram Ghimire, was produced from judicial custody for recording of his confessional statement. Accordingly, I have recorded the confessional statement of accused Ram Ghimire as provided under section 164 of the CRPC. Accused Ram Ghimire has confessed the guilt. One lady was killed at their residence, and on the next day morning, they took the dead body to the riverside for dumping the same. Accused has confessed that he committed the crime as his wife used to doubt him for having extramarital affair with the same lady. On 11/8/2004, I again recorded the confessional statement of accused Usha Ghimire and Deepa Ghimire. Has confessed, accused Usha Ghimire has confessed before me that her husband Ram Ghimire used to work as a driver in a PST bus. He is supposed to return home at 6 p.m., but he used to stay with one lady, namely Ongtilu Tikhak, and comes home late night. I got annoyed because that lady used to tell me that my husband will marry her. On the date of incident, my husband took a bottle of liquor and Ongtilu Tikhak to our house. They consumed the same. The said lady was full drunk. I do not know the exact incident, but my husband Ram Ghimire has committed the offense. Accused Deepak Ghimire has confessed before me that she is daughter of Ram Ghimire and Usha Ghimire. On the date of incident, she was out of her residence, and when she came back, she found that this is Ongtilu Tikhak was at their residence, and she was totally drunk. Her mother Usha Ghimire asked her to help her for taking out Ongtilu Tikhak from their resident. Accordingly, both Usha and Deepa has taken Ongtilu out of their resident. Rest is the exhibit. Exhibit 6 confessional statement of Ram Ghimire. 7 and 8 are statement of Usha and Deepa Ghimire, Your Lordship. Cross parties, Your Lordship. On 29/7/2004, the accused was produced before me for recording his confessional statement. It was the order for fast production. It is a fact that I have recorded the confessional statement of the accused on 3/8/2004. The confessional statement of accused was recorded within 7 days of his arrest. Before recording of the confessional statement, I have followed the procedure as provided under section 164 of CRPC. Before recording of the confession, I made him understood that I am a magistrate and not a police officer. I have given him sufficient time for reflection. I kept him under the custody of my office peon for sufficient time before recording of the confessional statement. It is not a fact that I have not explained the accused that he is not bound to make the confession. It is also not a fact that I have not explained the accused that if any confession is made, the same will be used against him as evidence. The above statement, which I explained before the accused as provided under section 164, is recorded by me in the confessional statement itself, Exhibit 6. I explained the statement to the accused in English and Hindi. He could not understand English. The accused given the answer statement before me in Hindi, and I have recorded the same in English, and thereafter again explained the statement recorded by me to the accused in Hindi. It is a fact that I have not noted in the statement that I read over the statement to the accused in Hindi. I have made the memorandum on the bottom of the statement that the confessional statement was recorded in my presence and contains the true statement of the confession of accused Ram Ghimire. After recording of the confessional statement, I remanded the accused Ram Ghimire to judicial custody. It is a fact that in 164 form, I have not mentioned the date of production of accused and time of reflection given to the accused before recording of confession in respect of accused Usha and Deepa, Your Lordship. Accused Usha Ghimire has stated before me that she does not know anything about the murder. It is a fact that accused Deepa has stated that along with her mother, the deceased was taken out of her house towards Riverside. Your Lordship, our ground is basically on the confessional statement, Your Lordship. So before I come to my ground, I will just briefly, shortly read out the part to which IO has stated in this case. Actually, Your Lordship, IO died during the course of trial. So the statement of OC of that concerned police station was recorded, and which is at page 68, Your Lordship. Presently, I am posted as the OCPS Meow. As per record, Meow PS case number so-and-so was registered at Meow PS in view of an FIR filed by Meghnad Kaur. The case was investigated by SI Mr. BB Gurung. Said investigating officer Mr. BB Gurung is no more. Hence, today I appeared with the record for adducing evidence in the present case as called for by this court. During investigation, Mr. BB Gurung has visited the PO, conducted inquest, sent dead body for PME, collected cigarette matchbox, and even collected glass and sent for forensic examination. The IO has recorded the statement of informant and available witness as provided under section 161 CRPC, arrested the accused person, and their confessional statement were also recorded through magistrate as provided under section 164 of CRPC. On completion of the investigation, the IO has submitted charge sheet against 3 accused persons, namely so and so. Exhibit 1 is the inquest report. Exhibit number 9 is the FIR. 10 is so and so. 11, 12 is seizure memo. 12 is the seizure of DAO. 12 is the signature of the IO. Now, cross part is that during the year 2004, I was posted at Daporijo. I joined as OCPS Meow on October 2018. I have no personal knowledge regarding the present case. Whatever statement I have deposed before the court is as per record. Even the exhibits are as per records. Now, Your Lordship, again 313 was complete denial, Your Lordship. In the case at hand, Your Lordship, Your Lordship, our main ground is that, Your Lordship, that learned trial court below has acted on confessional statement which is not sustainable in the eyes of law for the 2 reasons, Your Lordship. First is, Your Lordship, in 164 form, Your Lordship, there is a judgment, recent judgment in where your lordship was presiding, was there in the bench, that is Raju Kumar Deka versus State of Assam. There also the fundamental fact that while recording 164 statement, magistrate is also required to ask the accused as to why he decides to confess the guilt has been given importance, your lordship. So I have a copy of website copy, your lordship, which I would like to share.
What website?
Court website, your lordship, and equivalent citation is there in GLT, which I have written down also, your lordship. On the right corner side, 2023 for GLT 882, it has been. Page para 27 is relevant, your lordship. Dear your lordship, this honorable court held that para 26. In the instant case, it is clear from the format of the confessional statement and from the evidence of the magistrate, PW9, that the time given for reflection has not been specifically mentioned. This discrepancy thwarts the credibility of the confessional statement. Moreover, the format also reveals that magistrate has not noted down in the format if the appellant was produced from the police custody or from the judicial custody. Your lordship, here one important fact which I would like to bring into your lordship's notice is that there is no corresponding order of producing the accused before the magistrate on the very day on which the confessional statement is shown to have been recorded, your lordship. The corresponding order, there should have been a corresponding order of
So
the.
it was not asked.
It was
No corresponding order in the LCR.
not in the LCR, your lordship. Your lordship, para 27. Oh, yes, para 27, your lordship. It was also being held by this court in Rafiqul Islam versus State of Assam, reported in 2011, so and so. Though the confessional statement of the accused was recorded in a format prescribed for recording confession under Section 164 of the Code of Criminal Procedure, the mandatory requirements of Section 164 of the Code of Criminal Procedure have not been strictly complied with in the instant case. The provision of subsection 2 and 3 of Section 164 of the Code of Criminal Procedure are mandatory, and under the said provision, magistrate is required to explain to the accused before recording the confessional statement that he was not bound to make confession. If he does so, it might be used against him, and even if he does not confess his guilt, he would not be sent to the custody of the police. Besides the above explanation, the magistrate is also required to ask the accused as to why he desires to confess the guilt. In the absence of any of the above requirement, the confession should be treated as incomplete and the same cannot be used against the accused. The above requirement has been made to satisfy the magistrate that the confession was voluntarily and fit for giving certificate under subsection 4 of Section 164 of CRPC. In the instant case, the magistrate failed to inform the accused that even if he does not want to confess his guilt, he would not be sent to police custody. In Gendra versus State of Assam, this court held that confessional statement recorded without informing to the accused as to why he desires to confess, and he would not be remanded to police lockup even if he does not confess the guilt, cannot be relied on. Without such important thing being done, your lordship, if we see the confessional statement, which is at page 32, your lordship, the questions that were asked was that I am not a police officer, page 32, your lordship. I am not a police officer. I am a magistrate. Do you know? Yes. You are not bound to make confession. You confess that will go against you. Yes. Whether you are forced by somebody to confess, no. Whether you are coming to confess voluntarily, yes. Whether you are induced or threatened by police to confess, no. Now the fact that whether if you confess, you will not be sent to the police custody, that question is not here, your lordship. And the reason for why he is making the confession, that question is also not here, lordship. Moreover, your lordship, it has been admitted by the magistrate, your lordship, that is at page 67. That part I again repeat, your lordship, that it is a fact that in 164 form, I have not mentioned the date of production of accused and time of reflection given to the accused before recording of the confession in respect of accused Usha and Deepa, your lordship. Under such circumstances, your lordship, it is highly unsafe to rely on the confessional statement, your lordship, that too which has been retracted.
Magistrate did not ask whether he was in police lockup or he was brought from jail.
Yes, that question was also not found any place here.
Okay. Anything else?
Secondly, your lordship, the for the confession was made in Hindi language and it has been recorded in other language. So I would not press much on that ground, your lordship.
RNAC.
And leaving that confession, your lordship, non-recording of informant. The first thing, your lordship, in any case under section 302, the prime element of homicidal, death being homicidal in nature has to be proved, your lordship. Now, when the same thing has been raised before the learned trial court, your lordship, learned trial court at at page 97, while deciding the point for determination was whether death of late Ontilu Tikhak is culpable homicide amounts to murder or not. So 95 is that point for determination.
95.
Yes, 95 is the point for determination. That point for determination is whether death of late Ontilu Tikhak is culpable homicide amounts to murder or not. And while discussing that, your lordship, this page 97, para 33, there, your lordship, our plea has been discussed and it is also plea of the defense that size of cut injury is not mentioned in the PME report, but on perusal of Exhibit 3 PME report, it is found on the column of external appearance that there was incised cut injury seen on the neck where 2/3 of the neck and anteriorly is totally sliced just 2 centimeter above the stenosis line, and trachea, oesophagus, carotid arteries, veins, all are cut by sharp object. In view of above, we don't think anything more is required to explain the injury sustained by the deceased. It is pleaded by the defense that the doctor has not mentioned as to whether the death was suicidal or homicidal in nature. On perusal of the PME report, it is observed that as per the opinion of doctor regarding nature of injury on the dead body, it was of such serious which caused immediate death of the deceased. In such a situation, had it been caused by the deceased herself, the sharp object used to cause the injury might have been recovered near the body, but material on record does not reveal any such recovery of any such sharp object near from the dead body. But Exhibit 12 reveals that thou allegedly used for cutting the neck of deceased was recovered from the residence of accused one Ram Ghimire, situated at TPT colony, Meow. There is no material to show that the death of Ongtilut is suicidal or not homicidal. As such, the plea of defense is not tenable. While holding that it is not suicidal, it is homicidal, the learned trial court has said that the sharp object has not been found near the body, your lordship. But your lordship, here one important aspect is that the informant who first chanced upon the dead body was not examined. Neither the IO has been examined. So the best person who could have confirmed whether any sharp object was near the dead body or not was the informant or the investigating officer. Both of them have not been examined, because of which your lordship, holding that the death is suicidal, the death is not suicidal or homicidal, is, your lordship, bad in law.
Anything else?
Next is, your lordship, the statement of Bhakte Tamang, where a suggestion was he was confronted with a question that he had stated before the police regarding involvement of any other person other than Ram Ghimire, and he denied that. Your Lordship, since IO could not have been examined, due to which we could not have proved that contradiction, Your Lordship. So, Your Lordship, I understand that non-examination of IO is not fatal, but in some circumstances, it has to be seen in the context of the facts of the case, Your Lordship. In this case, Your Lordship, had the IO been examined, had the accused been provided with the opportunity to confront that thing, Your Lordship, then the fact that regarding the involvement, regarding his statement about the involvement of other person other than Ram Ghimire could have played a big role in the defense of the accused, Your Lordship. So because of non-examination of the IO, Your Lordship, the accused has been prejudiced, Your Lordship, thereby vitiating the prosecution story, Your Lordship.
He could have prosecuted the other IO, OC who was present.
Other OC, he was only going through the record only, Your Lordship. Whatever was there, he did not have any personal knowledge as per his statement.
On which point you have suggested?
I suggested that it is
Only on the contradictions.
yes, it is not a fact that I had stated before the police involvement of any other person other than Ram Ghimire. Our defense was that it has been stated by him in 161 state.
Only under contradiction.
Yes.
That can be affirmed by the other, I think so.
Now, Your Lordship, this seizure, the seizure has been also relied on, Your Lordship. That is the seizure memo exhibit 12 that Your Lordship would find at page 16 to 18, Your Lordship, of the paperwork. Your Lordship, place of seizure was residence, that is at page 16, Your Lordship. The seizure of Dow, on which the trial court relied, Your Lordship, place of seizure was this, date and time was this. Now witnesses were S.I.S. Singh, R.N. Jha, K. Hapu. These witnesses are not in accordance with section 100 of CRPC. They are not the independent witness. Rather, they are from the police team itself, Your Lordship. And more so, Lordship, they have not been examined. In order to prove the seizure, these seizure witnesses ought to have been examined. In that case only, Your Lordship, the learned trial court could have come to the finding that yes, Dow was recovered from the house of the accused, Your Lordship. So without getting sufficient evidence to that effect, Your Lordship, the learned court erred in holding that Dow has been recovered from the residence of accused. So this much.
Yes.
Your Lordship. If I may, firstly, Your Lordship is, as already submitted, there are very few statement of the witnesses as well as the confessional circumstances. Last seen is the theory upon which the accused was convicted, Your Lordship. Now, if I may take Your Lordship to the page 1, Your Lordship, I won't read the entire FIR, but I'll just. Your Lordship will see the deceased was found dead by one Meghanathu Gaur, Your Lordship, who is not known to the deceased, Your Lordship. Once on 28th, he had just found out the body of the deceased, Your Lordship, and therefore the police was informed. Now, if I may take Your Lordship to the seizure list, Your Lordship, that is at page number 15.
Yes.
Yes, these are the seizures that was made in the in the place of occurrence, Your Lordship. Lordship will see the fifth serial number, empty cigarette belt with navy cut, 1 number, matchstick burn, 12 number cigarette, and 10 mm blood preserved in the cloth. Now, if Your Lordship will come to page number 16.
Yes.
This seizure was made at the place resident of the accused. Your Lordship will see at serial number 1, place of seizure. The serial number 5 describe the seized articles as thou local made one number with cupboard wrapped with monkey skin, manufactured local made nishi dao, lens so and so, handle so and so, breadth so and so, black long pen number suspected to be blood stain. Now, if your lordship will see, the third seizure witness was a foreman state transport meow. At page number 19 is the inquest report, your lordship. Nineteen at serial number 5, the IO opined that the case is of a murder case, your lordship. The very important statement and the deposition was of the son of the deceased, your lordship. Your lordship will see at page number 20 is the deposition, that is 161, your lordship. He has stated clearly that his mother has dropped him, and that she was last seen talking to the wife of the accused, your lordship, and thereafter she had never returned, your lordship. Now at page number 21 is the medical report, your lordship. Opinion, your lordship, at page number 24, your lordship.
Yes.
As rightly pointed out, your lordship, there is nothing as to describe as to it was a suicidal or homicidal, your lordship. Now, your lordship will come to page number 25, your lordship. This was a exhibit A by the accused, your lordship. He had submitted this exhibit for his defense, your lordship. Your lordship will see that the incident has taken place on 27th, your lordship. And the superintendent has given this certificate in the year 2016, stating that on the next date, that is on 28/7/2004, the vehicle number as per the record of the moment and the register log at this office was driven by the accused person, your lordship. Your lordship will see the date, your lordship. 27th is the day of incident and 28th is the day when the body was discovered, your lordship. (164) is at page number 32, your lordship. I'll make a clearance to that effect, your lordship. As per my understanding, your lordship, all the formalities as per the 164 recording of the confession has been complied with, your lordship. Your lordship will see the executive magistrate, though he did not have any, because it was taken in the year 2004, your lordship, and the statement of the magistrate was taken in the year 2019, your lordship. Now, to clarify this, where if he was given a reflection time or not, if your lordship will come to page number 104, your lordship. And I have also checked the LCR, your lordship. All the orders are as per the paragraph 49 of the judgment, your lordship. 104, your lordship.
Yes.
If I may read, your lordship,
Yes.
paragraph 49. It is submitted by the learned counsel for the accused person that there is a contradiction in the position of PW8, who is the judicial magistrate, your lordship. It is submitted in chief of PW8 that accused Ram Gimire was produced from judicial custody on 3/8/2004 for recording of his confessional statement. Whereas during cross-examination, he has stated that accused was produced for the first time on 29/7/2004 for recording of his confessional statement. To find out the reality of the fact, I have seen that order sheet of GR record and found that accused Ram Gimire was arrested on 28/7/2004 and he was produced on the same day before the learned JMFC, praying for his remand in judicial custody for 14 days. Learned Magistrate White order dated 29/7/2004 has remanded accused Ram Gimire to police custody for 7 days. On perusal of the record, it is found that on 2/8/2004, accused Ram Gimire was again produced before the learned magistrate by the IO with a prayer for recording his confessional statement. Learned magistrate has not recorded confessional statement of accused Ram Gimire on 2/8/2004 as he was produced from police custody. Learned magistrate has remanded the accused in judicial custody and fixed the matter on 3/8/2004 for recording of the confessional statement of accused Ram Gimire. Exhibit C6 reveals that on 3/8/2004, accused Ram Gimire was produced from the judicial custody before the learned magistrate. Now, your lordship is well aware that for any order passed by the judicial magistrate is a record of the court, your lordship. Now, to verify the argument and also the deposition made by the PW8, which is the magistrate, your lordship, a clarification was made by looking into the LCR. Now, before the expiry of 7 days, your lordship, he was brought before the magistrate for recording his statement on 2/8/2004, your lordship, from the police custody. The magistrate, in fact, did not record, taking into consideration, firstly, that he was produced from the police custody, your lordship. Thereafter, he was sent to the judicial custody, and on the very next date, when he was produced from the judicial custody, his statement was recorded, your lordship. Now, if I once again read the 164 of the accused person, which is at page number 32, your lordship.
Yes.
I may read from the second paragraph, your lordship. Late Ongtilo Thikak was known to from 1991-92 onwards when she was studying in high secondary school, Miao. Her husband Lama is also known to me from last 10-12 years. 4 or 5 months ago, probably during the month of January, she met me at Miao Market and invited to her house near Forest Colony, Miao. For the first time, I came to his house, and from that day onwards, I was a request visitor. We had also physical relation. During the month of May, on my Mrs. Osha Gimire came to know about our relation, and for which she abused me and the lady for the first time. On 27/7/4, when I reached Miao from Dibrugarh at around 1700 hours late, Mrs. Ongtilu Thikak was our government quarter and was fully under influence of alcohol and was shouting that she will take me with her and will kill my wife and children. At this, I instructed my wife and daughter to take her out from our quarter and keep her near the jungle area. I followed them, and in between cooperative store and Sri Gumjanong residence, I asked my wife and daughter to return back to our quarter, and from there I accompanied with late Ongtilu Thikak to the old mill building, which is situated about 100 meters away from Sri Gumjang Singfo's residence. She was at that moment not in sense, and I, with my dao, which I brought with me from my quarter, slit her throat with the dao where she breathed her last. Now, your lordship will see that he has retracted his confession, your lordship. There is no doubt to that. Under 313, he has clearly written. But can a retracted confession be thwarted, your lordship, only because the confession has been retracted? No, there has to be a corroboration. Since it's a case of circumstantial evidence, there has to be a corroboration to such confession as well as to the retraction, your lordship. Now, if I may take your lordship to the confession of both these mother and the daughter, your lordship. Mother clearly states that she has taken, she was in the deceased was in a drunken state, your lordship. She had taken on her husband's instruction, she had taken the deceased to the jungle, your lordship. The daughter also collaborated that when such incidents was happening, she was not in the house, but later in the evening, her mother asked her to help her take the deceased to the jungle, your lordship. Now, your lordship will see that both the mother and the daughter were acquitted from the charges, your lordship. However, their confession, though it does not implicate any, would not imply on the accused, your lordship. However, it will be seen as a corroborative, your lordship. The circumstances, the chain of event goes, your lordship, that the last scene was with the wife of the accused by the son of the deceased, your lordship. Later on, when the accused comes to the home, your lordship, they find that they have some arguments, your lordship. He asks his wife and the daughter to take her to the jungle. They take her midway to the jungle. Thereafter, the accused comes and, as per his confession, he slits her throat and kills her, Your Lordship. Now, if I may take Your Lordship to the FSL report, which is at page number 39.
39?
39.
Yes.
The seizure made in the on the spot, Your Lordship. The blood, Your Lordship. The result of the examination, Your Lordship will see, gave positive test for human blood, but gave test for blood only, but its origin could not be ascertained due to insufficient material. So condition of comparison of blood group does not
Blood
arise.
was supposed to be matched.
Yes,
His blood was supposed to be lifted.
yes, both the bloods were supposed to be matched, Your Lordship.
But then-
Examined, Your
What
Lordship,
happened?
but only insufficient samples were given to the forensic, and therefore forensic result could not be ascertained as to whose blood it was, Your Lordship.
This happens in Assam also.
Yes,
They'll take blood from one sample and they'll not match it with the victim or the accused.
yes. Now the seizure of the dhow was made. However, Your Lordship will see why was this dhow not considered during conviction, Your Lordship?
We'll continue tomorrow. We'll pass the order tomorrow, complete it. You are from Assam?
Yes, Your Lordship.
Oh, you won't be here present tomorrow.
Present, Your Lordship, it may be difficult.
I'll just take 10 minutes, Your Lordship. I have certain judgments. I'll place it before Your Lordship, Your Lordship. Otherwise,
Okay, then you want to conclude today?
No, I have to wait. Can it be on 16th, Your Lordship?
No. 16th, you'll go back and come back again. No. Then
Okay,
I'll
then
reserve,
tomorrow.
huh?
So, okay, then I will do.
She'll take only 10 minutes, then we
I'll-
can pass the,
yes, Your Lordship
Yeah.
can reserve the order, Your Lordship.
tomorrow, you'll be here tomorrow.
Yes, Your Lordship.
Have you booked tickets?
No.
No. Okay, then we'll continue tomorrow because he's also got a single bench. I've also got a single bench. We'll continue tomorrow and tomorrow we'll pass the order. We'll start with the order and then we will take your concluding remarks. We have only 10 minutes left.
Yes,
All right. Okay.
tomorrow, Your Lordship.
Yes, yes. All right. Conclude, you
Yes.
conclude it.
Now, I'll place only the citations, Your Lordship. This is 2014 5 SSC 353, Your Lordship. Rajkumar versus State of MP. I'll be relying on paragraph 11 and
2014 SCC,
5 SCC 353, Your Lordship.
2014 5 SCC 353.
3, Your Lordship.
Para?
Para 11 and 12, Your Lordship.
Okay.
Your Lordship, this is specifically with regard to 313, Your Lordship. That every accused, while putting up a question under 313, has to make an explanation, Your Lordship. If there is no explanation as the question put up to him, Your Lordship, the court has the liberty to interpret the same, Your Lordship. The second is with regard to retracted confession, Your Lordship.
Para?
My paragraph reliance is on 16, 17, 18, and 19.
This was 11 and 12, no?
Yes, Your Lordship.
Yes.
16, 17, 18, and 19, Your Lordship. This is with regard to retracted confession, Your Lordship. The other is of non-examination of the informant, Your Lordship. Your Lordship will see when the IO has himself expired, Your Lordship. The IO was represented by the present officer in charge, Your Lordship, who was never put up, no question was put up to him, Your Lordship, with regard to any queries. Paragraph 13, Your Lordship. 13 last stanza, Your Lordship.
This is 2004 SCC.
Now, this
That
is
the second one,
second one.
or retracted confession.
Retracted confession is 2004 7 SCC 779, Your Lordship.
2004. And the last one is relating to?
This is non-examination of informant, Your Lordship, which is paragraph 13, 2007 15 SSC 393.
2007.
15 SSC 393.
Non-examination of informant.
Non-examination of the informant.
Paragraph?
Paragraph 13, Your Lordship.
Okay. 15.
This is non-examination of the informant and other material witnesses, Your Lordship. My last reliance is 2022 10 SCC 321, Your Lordship.
Two 2022.
10
10
SCC 321, Your Lordship.
This is relating to?
1, Your Lordship.
And paragraphs?
Paragraphs 22.1. It's 22.1, 22.3. Those paragraphs are for the circumstantial evidences, Your Lordship.
All right.
Now, 22.9, Your Lordship, is with regard to expert's opinion, Your Lordship. That an expert is not a witness of the fact of evidence, but just an advisory character, Your Lordship. So any report MLC of the expert opinion has to be taken into consideration on which aspects, Your Lordship, is at paragraph 22.9. Lordship, I would also like to rely on 22.12, Your Lordship. 22.12 is with regard to irregularities in investigation. Can certain irregularities in the investigation can thwart the entire prosecution's case, Your Lordship?
This, what is the crux of this 22.9? It's relating to expert's opinion.
Or expert's opinion, Your Lordship.
Is not
The credibility
conclusive
of the,
evidence.
yes, the credibility of witnesses, expert witnesses, Your Lordship.
All right.
22.12 is irregularity in investigation, Your Lordship. Now, 22.13 is the last seen theory. Now, 24.5 is also with regard to irregularity, minor irregularity and inconsistency, Your Lordship, in proving the evidences, Your Lordship. 24.5, Your Lordship. Yes, Your Lordship, while concluding my submission, Your Lordship will see that confession and last seen theory as well as circumstantial evidences were the ground for conviction, Your Lordship. The corroboration, the chain of events, Your Lordship, which can be ascertained from the statement of PW2's the son, Your Lordship, the statement of the accused persons, Your Lordship, and two other co-accused person, Your Lordship. The co-accused person does not say that he has murdered, therefore their confession does not implicate him, Your Lordship. Their confession can be taken as a corroborated to join the chain of event, Your Lordship.
Yes.
That's it. And with regard to
I
the
noted it down.
with regard to the recording of the confessional statement, Your Lordship, the LCR is also very clear with regard to that, Your Lordship. He was given ample of time, Your Lordship. His confession was to be recorded on 2. However, he was given time till next date and the confession was recorded on 3rd, Your Lordship. And with regard to the examination of the witnesses, Your Lordship, that has also to be also been given in the judgment, Your Lordship. Deeply.
You want to reply?
Yes, Your Lordship. With regard to the judgments, I have not gone through, Your Lordship.
So you can reply tomorrow then?
Yes, Your Lordship.
Then we'll finish it off tomorrow.
This.
Hmm?
He said, it's for 164.93.
Hmm.
These questions should not.
Ask them. You ask them.
Whatever his submission regarding the he'll not be sent to police custody and then why he has come for confession. That has
Yes.
not been endorsed and reflected in the
But
164.
it's not reflected in
Because it's,
160.
according to him, it's a mandatory 164.
Once it's not recorded in the 164, Your Lordship, in the 164 format, Your Lordship, but then it's recorded in another order sheet, Your Lordship. That's why I have stated, Your Lordship, the LCR is clear with regard to that.
It's in the
It's in the LCR. I have a certain
order sheet.
Order sheet. Yes.
Okay.
order sheet.
Your Lordship, I want to add here, because I have also gone through the LCR, Your Lordship. But on the day of confession day was 3/8, I suppose. And he was brought on 2nd,
Yes.
there is a corresponding order. But on 3rd, there is no any corresponding order.
Okay. Just must reply and note it down in the record.
She said she was brought on 2nd
Yes.
from the police custody and
Yes.
then they sent back. And on 3rd, he was remanded to, judicial custody.
Judicial custody.
On 3rd, he was brought from judicial.
Yes, Your Lordship. So on the very day, as far my little knowledge is concerned, on the very day of the production, that there has to be a corresponding order, Your Lordship, that the accused has been produced from the judicial custody for confession, and he has been he is seemed to be fit and sound, and so his confession is being recorded. There has to be a separate order sheet. That
No.
order sheet has not been found in the record.
I'm not aware of such
We'll find out.
procedure, Your Lordship.
In
That
the
separate
trial
order has to
practice,
be
I've
there, Your
seen
Lordship,
that,
because
so
as
that's-
far as I understand, in the confessional order, Your Lordship, the day and from which custody he has been brought, Your Lordship, all those are recorded, Your Lordship.
And Your Lordship, why he has been given 1 day time, that has also not been explained. If
Because
there is any order.
Because he
that
was
has to be there.
produced from police custody.
So during the time I have given you 1 day time for reflection, that has to be explained by the magistrate.
So we'll put only one case more than the one case.
This
We
thing.
want more for DB. We'll fix only one case. Tomorrow we'll finish it off.
Yes, Your Lordship.
We'll try.
Yes.
Cannot give you my word, but we'll try.
Deeply.
No, I'm asking for you if you can be comfortable. So, arguments I have noted down. You can spin it up in this manner here over here. Yes,
Within course of the day.
petitioner,
Yes, I am for the piece.
K. Lolen.
K. Lolen.
Lolen counsel for the petition, Mr. K. Lolen is present.
I am for the Union of India, my lord. Representing respondent number 5 and 6, but name was not reflected.
Learned counsel, Mr.
M. Sora, on behalf of M. Kapo.
M. Sura, on behalf of learned counsel, Mr.
M. Kapo.
M. Kato. Learned Counsel UI.
I'm appearing for 1 and 4.
Is present. Learned Counsel Miss
Arbasar,
Arbasar is present on behalf of respondent number 1.
1 and 4. 4.
1 and 4. UI is respondent number 5 and 6.
My lord,
UI
name
5
was
and
not
6.
reflected in. Earlier.
Yes, yes. I'll pass an order. Yes? No. The petitioner to furnish copies to the respondent during the course of the day. The name of Learned Counsel, Learned DSGI, no?
Yes, ma'am.
M Kato, you just write DSGI, huh? Learned DSGI. You say M Kato to be reflected in the cost list.
And also, I'd like to mention,
If it's you, someone, anyone can.
item number,
It's only one case for BB, the case which I have today. Only one case for BB to pass. Other case we have to wait for DB. Yes.
I'd like to mention item number 25
Hmm.
on behalf of our second.
Arsoike,
Yes.
Learned
Because of
Counsel,
some
Mr.
urgency, we left the
L,
premise.
T, what was your,
Your lordship, government,
at K Lolan,
yeah,
on behalf of Learned Counsel, Mr. Arsoike,
ourselves,
has prayed for adjournment.
yes, yeah,
With the with the consent of the other side, has prayed for adjournment.
this is the matter, after 2 weeks. Lordship.
3 weeks, your
This is the
lordship.
matter after
3 weeks, your lordship.
3 weeks. This is 25.
Yes, item 25. Here, the opposite parties needs to find the.
Yes, your lordship. We have not received the Paravas reply.
Hmm.
That's why, your lordship,
Hmm.
for filing counter affidavit.
You have not received instructions.
Yes, your lordship.
Learned Counsel Miss
P. Pangu, your lordship.
P.
Pangu.
Pangu has submitted that she will obtain instructions from the respondents,
Yes,
opposite
that's
parties, from the respondents to submit their affidavits.
Yes, sir. Oblige, your lordship.
Deeply obliged.
My pleasure, Your Lordship. Your Lordship, I beg to mention item number 22 and 23.
22 and 23.
On behalf of the Kamluk for the petitioner, this matter has become infructuous, Your Lordship. So
Okay.
allow me to withdraw this petition.
It's-
We have already informed the
Who is on the
respondent.
opposite side?
My lord, I am for the item number 21. Connected matter. We have-
Anybody is appearing for the respondents in this item number 22 and 23?
I'm appearing on behalf of standing counsel Tabatagum.
22 and 23.
Yes, Your Honor.
All right. Learned Counsel, Mr.
M. Ratan,
M.
on behalf of the Kamluk.
On behalf of Learned Counsel for the petitioner, Mr. D. Kamduk has submitted that as the matter has become infructuous, he is willing to withdraw the petition. Heard Mr. Yes,
H. Tai.
H.
Tai.
Your name is not here.
So
Not
I'm appearing on behalf of
H. Tai, on behalf of Learned Counsel, Mr.
Tabatagum. Tabatagum, who's the standing counsel.
T. Tagum, Learned Standing Counsel for Education Department,
Yes, Your Honor.
I'm for
22 and 23.
no, Your Lordship, 23. I'm for the respondent number 3.
So this is only for 22, huh? This is only for 22. The Learned Counsel for the respondent has no objection if the petition is withdrawn.
Lordship, here I am representing respondent number 4, private respondent number.
Which one? 23?
Item 23.
20?
3.
3. No, I'm only on 22. Petition is dismissed.
Total on withdrawal, Your Honor.
Dismissed on withdrawal, matter is closed. Then that for petitioner, the same order in item number 23, for the petitioner, same order. And then for respondent, we have different respondents here. You are for respondent number, are you representing any respondent in 23?
Yes, Your Honor. Said standing counsel 1.
This is the education department.
Education department, same lawyer. And then
And I am for private respondent number 4 in both cases.
Learned Counsel, Mr. T. Lolen.
Okay, Lord.
A.K. Lolen is present on behalf of the respondent number 4 and
Yes.
4.
Yes.
In both the cases, please insert this in the first case also. In both the cases. And for 23,
3 years. Respondent number 3 years.
Learned Counsel, Mr.
Why?
Y
Rida.
is present on behalf of respondent number 3. The learned counsel for the respondent has submitted that they have no objection if the petition is withdrawn. Petition is dismissed on withdrawal. Matter stands closed.
Much obliged. My lord, in item number 21, I am seeking time to file my affidavit.
You are seeking time
Yes,
to file affidavit. Item number 21. Petitioner is not present. Not
My lord,
represented.
this is a so moto content.
So motor content, okay. All right. Then, learned counsel, Mr. O. Modi has prayed for time to file affidavit. Leaves the matter after 2 weeks.
6 weeks, because my lord, this respondent is
The
the.
petitioner is not present. Have you taken the consent? 6
Yes, ma'am,
weeks.
I have taken.
With the consent of the other side has prayed for time, leaves the matter after 6 weeks. 21, huh?
Your lordship.
Hmm.
I'd like to mention item number 32, your lordship.
32.
Yes. I'd like to seek 4 weeks time.
And what about the other side?
I've taken the consent here.
Learned counsel, Mr.
D. Doyam.
On behalf of,
T. Bayor.
oh, D. Doylam.
Yes.
Oh, his name is here. Learned counsel, Mr. D. Doylam. For the petition, learned Mr. D. Doylam, learned counsel for the petitioner, with the consent of the other side, has prayed for time. Why have you prayed for time?
Your Honor, actually, the lead counsel is absent. After he comes back from his village, he will do the needful.
Okay,
I mean, the further procedure.
prayed for time. On behalf of learned counsel, Mr.
T. Bayor.
T. Bio.
Yes, your
Is the matter after how many days?
4 weeks.
4 weeks.
Obliged.
Lordship, I beg to mention item number 31.
31.
Yes, Lordship. Consent has already been taken from the other party. Consent has been taken from the other party.
Yes, yes.
Matter may be fixed on 22nd.
All the hearing cases are taken time today. Because in the morning I have heard one case, so this is a matter relating to 2017, whole pending case. Should I grant you time? Let me see the record. Are you consenting for the time?
Yes, your Lordship.
Whole pending case? 2017, let me see. Learned counsel, Miss,
RC Launcher.
with the consent of the other side,
On behalf of Mr. G. Tarak, Standing Counsel RWD.
has prayed for adjournment. List the matter
Matter may be fixed on 22nd, Lordship.
on
22nd.
22nd May. Miss, yes, Miss,
B. Mema,
is present on behalf of the learned counsel for the respondent, Mr.
G. Tarak.
Twenty-second of May.
Yes, Lordship.
Yes.
Your Lordship, I beg to mention item number 18. On behalf of respondent, Mr. G. Tarak, Standing Counsel of RWD, Your Lordship. And Your Lordship, the main counsel is out of station due to some personal issues.
G Tarak.
G Tarak, your lordship.
Learned Counsel Miss So and so on behalf of Learned Counsel Mr. G Tarak with the consent of the other side
Yes, your lordship.
has prayed for adjournment, list the matter on
After 1 week.
1 week.
And your lordship, also item number 28.
Same order. 1 week.
1 week.
Yes, your lordship.
For last 3 occasions, like they have not filed their affidavit. This is due to non-grant of interim order. They are taking time and time. That's one. So
You okay, you are on interim.
I'm for the petitioner. No interim was
No
granted.
interim order.
After 1
Not
week.
same order, huh? Learned which item number 20?
8.
8. Learned Counsel Miss So and so on behalf of Learned Counsel Mr. G Tarak has prayed for adjournment. Learned Counsel Mr. J Jini.
PP charge.
B Learned Counsel Mr. B Peter has raised objection stating that stating that several adjournments have been obtained by the respondents and no further adjournments adjournment may be granted. List the matter after
1 week.
1 week positively.
Deeply obliged.
Obliged.
May it please your lordship. Lordship, I would like to mention item number 9. This matter may be fixed after 1 week. I have taken consent of the other side.
Learned Counsel Mr.
A Bhattacharjee.
A Bhattacharjee.
Yes, lordship.
With the consent of the other side has prayed for adjournment. List the matter on
After 1 week.
after 1 week.
Obliged.
May my lordship. I beg to mention item number 15, my lordship.
13,
15.
15, okay.
This matter is listed after 2 weeks, my lordship. We have to file affidavit in this.
Learned Government Advocate Mr. K. Wangmo, with the consent you take.
Lordship, I'm for the petitioner, lordship.
Huh?
I'm for the petitioner. They were supposed to file
With
affidavit.
the consent of the other side has prayed for adjournment. Heard Miss A. Appa
And Anju,
and Anju, Learned Counsel for the petitioner. List the matter after 1 week.
2 weeks, 2 weeks, my lordship.
Hmm?
2 weeks.
2 weeks, okay.
Obliged.
May I, my lord?
Hmm.
My lord, I beg to mention item number 7 and item number 12 on behalf of the Standing Council Power Department, Council L. Parme. Due to some medical emergencies, he's unable to appear
He's not
before the
well?
court. No, his father is in medical, my lord.
Other is not well.
Yes, my lord.
Learned Counsel Mr. So and so on behalf of Learned Counsel Mr. L. Parme with the consent of the other side has prayed for adjournment. List the matter on
After 3 weeks, my lord.
3 weeks. 7 and 12.
Yes, my lord.
All right.
May your lordship. On behalf of Standing Council Mr. Tawatagum, I'd like to mention item number 2 to 5.
2 to 5.
Yes, and 17.
2, 3, 4, and 5 and
And 17.
17. What is your same?
No, your lordship. In item number 4, I'm for the petitioner.
Yeah.
He's making a mention of 2, 3, 4, 5. These are connected matters.
2, 3, 4, and 5. In item number 4, you are the petitioner.
Yes, your lordship.
I'm for the 2 and 3.
Petitioner.
No. There is an interim order.
He is for the respondent, no?
He's
No,
for the
yes,
respondent.
So with the consent of the other side, if you have consent,
No.
Learned Counsel Mr.
Your lordship, in item 17, I'm for the petitioner.
17. He
17.
has not mentioned 17. 17?
17 also.
17 is well.
Okay. All right, 2, 3, 4, 5, and 17. Learned Counsel for Mr. So and so for the respondent on behalf of
Titagum.
Learned Counsel Mr. T. Tagum for the respondent with the consent of the other side has prayed for adjournment. List the matter.
Lordship, for filing affidavit in opposition, since till date they have not filed the affidavit, your lordship, for filing.
For has prayed for adjournment for with the consent of the other side has prayed for adjournment for filing affidavit in opposition.
4 weeks may be granted.
The Learned Counsel for the petitioner has raised objection. The list the matter after 4 weeks. 4 weeks?
Yes, Your
4 weeks. Everything is fine with 4 weeks,
Lots.
everybody? All right, then list the matter after 4 weeks. The respondent, one sole respondent,
Yes, Your Honor.
the respondent to file affidavit positively on the next date fixed.
Obliged.
Item number 2 and 3, there is an interim order.
12,
Item number 2 and 3, sir.
2 and 3 extra add karna 2 and 3 mein.
Interim is
It-
until further order in all the matters.
Interim order shall remain in force till then. Till further order.
Please, my
Yes,
lord.
yes.
My lord, I beg to mention item number 16. Here in the matter, my lord, I need to file additional affidavit. Item 16, my lord.
Learned Council Mr. N. Ram,
And Ram, yes.
has prayed for time to file
Additional affidavit, my lord.
additional affidavit.
Yes.
Learned Council Mr.
Government respondent, government respondent.
Government, you are present for government.
Yes.
Learned Council Mr. Learned Government Advocate Mr.
Why,
Government Advocate.
why Riram, your lordship?
Why?
Riram,
Reram.
Riram, yes.
Reram.
Yes, yes.
My lord, interim may be continued, my
Is
lord.
representing the
1,
state
2, 3, your lordship.
respondent number 1, 2, and 3. List the matter after
After 3 weeks, my lord.
3 weeks.
Lordship, interim order dated 19/3 may be
Yeah, yeah.
continued. My lord.
After 3 weeks.
2 weeks, your lordship.
2 weeks.
My lord, my client is out of session having due to health issues. Is Guwahati, my lord.
3 weeks.
Yes.
Interim order shall remain in force till then.
Much of it.
May I, my lord? Item number 33, my lord. I am for the state respondents, my lord. I'm not prepared, my lord. Can it be adjourned for 3 weeks, my lord?
3 weeks.
Yes, my lord. I've taken consent of the petitioner, my lord.
You are for
State, my lord. Standing Council Rural Development.
Learned Council Mr. B. Picha, Learned Standing Council for Rural Development Mr. B. Picha. R&D, no? R&D likho. With the consent of the other side,
My lord.
has prayed for adjournment to file affidavit in adjournment.
No, pleadings are complete, my lord.
Oh, please.
I'm not prepared, my lord.
That cannot be written, I think.
My lord. After 3
Has
weeks,
prayed for adjournment, list the matter after
3 weeks.
3 weeks.
My lord. Obliged.
Well, I'd like to mention item number 10, well, I'm
10.
10, yes, sir. I'm for the petitioner here. As per the registry note, the respondent number 1 and 2, they have received the ID card. Yet, but yet they have to file Wakalatnama.
They have received the ID card.
Yes, your honor.
Service is complete.
Yes. They have to file Wakalatnama. So
They
this-
haven't filed Wakalatnama.
No, your honor.
Learned Council, Mr. T. Tag. You are for T. Tagum, no?
Yes, your honor.
Mr. Yes,
H tie.
H.
Tie.
Tae, H.
T-A-I.
Tae,
Yes.
on behalf of Learned Council, Mr. T. Tagum, representing the petitioner, has submitted that notices were issued. Stop the office note dated 7/3/2024 indicates that AD card has been received in respect of respondent number 1 and 2, but Wakalatnama has not been filed. List the matter
After 2 weeks, your honor.
after 2 weeks.
Obliged.
May I please, Lordship. I beg to mention item number 8. On behalf of the funding, we need to file additional affidavit, Lordship.
Learned Council, Mr. So and so, on behalf of Learned Council, Mr. Deepangi,
Yes, Lordship.
with the consent of the other side, has prayed for time to file affidavit,
Yes, Lordship. Additional affidavit.
additional affidavit. List the matter after 3 weeks.
Obliged.
I beg to mention item number 24.
24,
man. And this matter has been in fractures. So I may be allowed to withdraw our petition.
Learned Council, Mr. O. Modi, has submitted that the petition has become infructuous. Learned Government Advocate Ms. P.
R. Basar.
I. Basar has no AP, huh? Government Advocate AP, Arunachal Pradesh, has no objection. Petition is dismissed on withdrawal. Matter stands closed.
Lordship. Obliged.
Item number 1.
My lords, may I also be permitted to mention item 30, my lords? With my lords.
30?
30, my lords, yes.
Yes,
My lords,
what?
yes, my lords, my learned friend had to file an affidavit, my lords, and
Hmm.
he has not filed it. Number one, my lords, and number two, this
We
matter
are,
has.
we are about to file Malad affidavit. So therefore, Malad, 4 weeks time may be granted, Malad.
4 weeks time.
Item number 30.
Yes.
He's
4
seeking
weeks
4
time.
weeks time.
All right, my lord. That, my lords, and
Learned
one more
counsel,
request,
Mr.
my
P.
lords.
Agar, yes, yes,
My lord,
yes.
this has to be fixed along with my lords WPC 552 of 2023.
No, Malad, let the first affidavit may be allowed to file.
All right, I have no difficulty, my lord, but it has to be heard together only.
Learned counsel, Mr. P. Agarwala is present on behalf of the petitioner, and learned DSGI, Mr. M. Kato, is representing the respondent and
All
has
respondent.
prayed for time to 4 weeks time.
Malad.
4 weeks time to file affidavit.
Yes, Malad.
List the matter after 4 weeks.
Malad.
My lords, interim may continue, my lords. Thank
Interim
you.
order shall remain in force till then.
Grateful.
May I, Malad?
Yes, yes, yes.
Item number 1, Malad.
Hmm.
I am challenging this impugn suspension order dated 1/12/2022.
Hmm.
Now, what happened, Malad? For alleged, Malad, purchasing of paper leak, Malad, paper, APCS paper, question paper, Malad, I have been suspended. Malad. So, Malad, after suspension, no review was passed, Malad, for extension of my suspension. Malad. That is the sole case, Malad. So at this stage, notice may be issued.
You want to stay?
No stay.
Huh?
No stay, Malad.
No stay.
Because I have been suspended, Malad. I am challenging the impugn order.
Okay, so I'll issue notice
Yes, Malad.
or suspended.
Yes.
No, of course, there cannot be any stay.
Yes, Malad.
Mr. Yes,
I'm appearing on behalf of standing counsel Tapatagum.
so notices to the other respondents then.
Yes, Malad.
Your correspondent number?
1 and 2.
1 and 2, Malad.
Oh, you are already present.
Yes,
Okay, then. No notice, you furnish.
Formal notice is not
You
required.
submit, yes.
Yes, yes, Malad.
Heard learned counsel Mr. B. Picha, no?
Yes, Malad.
Is present on behalf of the petitioner. The petitioner to take steps to issue formal notice to the respondents. No, not required.
Not-
He's already there.
Yes, Malad.
Have you received a notice? No.
No.
Petition copy, yes, there.
No, he's saying he has not.
Yes, you have received it.
Received.
Yes, sir.
Petitioner to take formal steps, you cut that out, strike it off. Learned counsel, Mr. P.
H. Thai.
H. Tara.
H. Thai.
H. Tai is present on behalf of Learned Standing Council Education, Mr. T. Tagum. He has accepted He has accepted notice on behalf of the respondents. So no formal notice is required to be issued. However, sufficient copies to be furnished during the course of the day. List the matter on.
3 weeks, only.
Yes.
After
List the
3 weeks.
matter after 3 weeks.
Malad.
Do you want any records to be called?
No, Malad. They have to satisfy, Malad, whether there was a review committee or not. Yes.
Pleasure.
Obligation.
Item number 6.
This item number 6, Malad, I would like to seek 2 weeks' time, Malad. Mr. Counsel, the leading counsel is, Malad, has some domestic problem, Malad, so he could not appear today. Mr. J. Gini, Malad.
Mr. J. Jimmy.
Yes, Malad.
Learned counsel Mr. B. Picha on
Yes.
behalf of learned counsel Mr. J. Gini,
Yes, Malad.
with the consent of the other side, has sought
2 weeks' time.
has prayed for 2 weeks time. All right, is it fine with you? 2 weeks time for
Maybe adjourn, Malad. Maybe
2
adjourn.
weeks time has
Prayed for adjournment of
has submitted for adjournment. List the matter after 2 weeks.
Malad.
2 weeks time वो पहले जो था, you strike it off.
Obligation.
Item number 11.
Yeah, Malad. Malad, this is a very simple case, Malad. This may be disposed of, Malad. Yes, Malad. What happened, Malad? For construction of 2-lane highway, Malad. Trans-Arunachal highway.
Yes.
2-lane Trans-Arunachal highway, Malad, the respondent authorities has initiated lane acquisition process, Malad. Now what happened, my lord, on 27/9/2012, my lord? Notification was issued, my lord. Now, after issuance of notification, my lord, assessment was done, my lord. Valuation of property, my lord. My lord, may I please come to page 33, my lord. First page 32, my lord. Page 32 would be. This is for order of, my lord, valuation for reassessment of compensation, my lord. Page
32,
yes, my lord. Issued by the ADC Jang, my lord.
Please read the order.
Yes, my lord. Yeah. The survey for reassessment of compensation of the land and standing properties in respect of Sri Yesi Punsok, son of so and so, Kharsa village of proposed BCT is hereby fixed on 26/2018, my lord.
Yes, yes.
Yes, ma'am. Now what happened on 26/2018, my lord? The assessment was carried out, my lord. Now after assessment was carried out, it was communicated to the Union of India, my lord, the officer in command 90 RCC, my lord, page 33, my lord. Top, my lord, on the top, my lord.
Which part?
Page 33, my lord.
Page 33. Yes, please read.
To the officer OC, my lord, 90 RCC, care of 99 APO, my lord. This is forwarding of, my lord, compensation assessment, my lord. On 22 October 2018, my lord. Now the compensation was made under 4 heads, my lord. Land, standing properties, forest products, horticulture crops, my lord. They are, my lord.
Yes.
Yes, on page. It starts from page 34, my lord. Page 34 is the land compensation, my lord. The value of land, my lord. And then, my lord, page 35 is the assessment valuation of standing properties, my lord.
House?
Yes, my lord. Standing properties includes house, my lord. And other properties, my lord. And, my lord, page 36 would be the assessment of, my lord, forest products, my lord.
Forest products, yes.
Yes, my lord. And the fourth one is, my lord, page 30. Yes, my lord. Horticulture crops, my lord.
Just let me just check the name of the petitioner.
Yes, my lord. Yesi Punsok, my lord.
Yesi Phunso.
Yes.
Yes.
Yes. Page 37, my lord, is a horticulture compensation for horticulture.
Yes.
Now, this was, my lord, concluded, my lord. It was communicated to the, my lord, the Union of India, my lord. The officer in command, my lord, 90 RCC. On 22 October 2018, my lord. It is in page 33, my lord. Now, since then till date, my lord, they have not acquired my land, neither acquired my land, neither paid any compensation, my lord. They have not taken any decision, my lord. Now, what happened, my lord? I have made representation, my lord, on page 39, my lord.
Page 39,
my lord.
Yes.
On 30/12/2019 before the ADC, my lord.
Please read it.
Yes, my lord. No objection certificate against my affected land property only. With reference to the above caption subject, I would like to lay down few lines for your kind consideration and necessary action, please. That I see Yesi Phunsok, affected landowner property at Chinese neighbor so and so, would like to inform your office that I wrote down a letter on dated so and so to the competent authority, OC 90 RCC and Commander 42 BRTF for seeking clarification on delaying of my compensation against my affected land property. The clarification was supposed to reach to me within a week after submitting my letter, but till today there is no response. The copy of same letter has been submitted to your good office on same following day. Taking the lieu of irresponsible attitude from the agencies, I have decided not to give my affected land property to them at any cost. I was victimized and neglected by this agency with no proper reasons. So, sir, kindly issue me no objection certificate against my properties and ensure me that these so-called agencies have no right to claim over my affected land properties in near future through any means. Also, kindly nullify all my compensation rates as I am starting construction of my dwelling house in my affected land. Therefore, I request your office to issue me no objection certificate against my affected land at the earliest so that I can initiate further.
Yes.
Now, why I am seeking NOC, my lord? Because the notification has been issued, my lord. The once notification has been issued, the assessment of my property has been valued, my lord. Now, I cannot construct new construction, my lord, over my land, my lord. Because of that, I have been seeking NOC from the concerned authority. Now, on 7 July 2020, page 40 also, my lord, I made the same representation, my lord. Now again, what happened, my lord? This page 43, my lord. Acknowledging my grievance, my lord. Page 43, my lord.
Yes.
Acknowledging my grievance on page 43, my lord. On 25th August 2020, my lord. The ADC Jang, my lord, has also written to the officer commanding 90 RCC, my lord, for necessary action, my lord, and status report, my lord. Because this my lord, this officer commanding 19 RCC, they are the requiring authority, my lord. May I read, my lord?
Yes.
With reference to the subject cited above, the Deputy Commissioner Jitsu Tawang, by letter dated so and so, has forwarded a copy of representation with relevant documents received from Yesi Funsok of Kharsa village regarding assessment of compensation of land and standing properties falling under right of way of BCT Road Kharsa at kilometer so and so. Further, it is to apprise you that Deputy Commissioner Tawang has already forwarded the assessment of compensation of land and standing properties in respect of Sri Yesi Funsok Kharsa village, which was duly signed by the constituted board members by DC Tawang letter so and so. Hence, you are hereby requested to submit a status report of the said issue at the earliest potential action from this end. Same letter, my lord, on page 46, my lord.
Yes.
Again, this ADC Jang, my lord, has written to the OC 90 RCC, GRIP, my lord. Now, there has been no response from the, my lord, this Union of India, my lord, this authorities of Union of India, my lord. Now,
That
what?
is that is a 90 RCC.
Yes, my lord.
Gref.
Yes, my lord.
That army, I think.
GRIP, my lord, they are not army, my
Road
lord.
building.
Yes, bro. Border Roads Organization, my lord. Yes, they are, my lord, respondent number 4 to 7, my lord.
Respondent 4 to 7, no?
Yes, my lord. Union of India starts from 4 to 7, my lord.
All right.
Yes, my lord. Now, what is my prayer, my lord? My only prayer is, my lord, for directing them to consider whether they want to acquire my land or not, my lord. At least intimate me, my lord. My lord, may I please come to my prayer, my lord. Page 24 of my writ petition.
Yes.
May I read, my lord?
Yes.
A writ of mandamus shall not be issued directing the respondent authorities, particularly respondent number 4 to 7, to take immediate decision to acquire the land of the petitioner by paying compensation as per reassessment valuation report or issue no objection certificate enabling the petitioner to undertake development activities over his area of land. But I'm only praying, well, let them take the decision whether they want to acquire my land or not. That is my prayer. With this observation, this writ petition may be disposed of.
Yes.
Malad, prayer, Malad, the sought for by the petitioner is Malad, the very fair and reasonable Malad. As because the Malad, the requiring authority, if they wanted to Malad acquire the land at all, Malad, the compensation can be paid. Malad, the acquisition has been done, Malad, while assessment has been was carried out, there Malad, the officer concerns were present. But after the Malad, everything has been done. Now they are neither they are acquiring nor they are paying the compensation. So therefore, Malad, the categorical directions may be given to the Malad, the deputy commissioner as well as the Malad, the respondent number 4 to 7. Whether they wanted to acquire the land, then compensation as assessed by the petitioner, the district administration may be paid, or else Malad, if they don't want require the land anymore, Malad, then the land, the proposed land can be Malad, reverted back to the Malad, the petitioner. So that Malad, at least verification and the determination, Malad, that decision can be taken by the district administration along with the Malad, the requiring authorities.
Within a period of specific period of 1 month, 2 months,
by disposing of this writ petition, if
Can
the
be
direction,
disposed of.
yes, Malad, if direction is given to the district administration, to Malad, the lies with the Malad, the requiring authority, whether they wanted to acquire the land or not, or if they don't want to Malad, acquire the land, then Malad, the land can be given back to the Malad, the petitioner and the landowners. Or Malad, if they wanted to acquire the land, Malad, as assessed by the Malad district administration, Malad, compensation can be paid to the petitioner. Malad, keeping the matter, Malad,
Ending in this manner.
no, Malad, at the PRO level is also not Malad, exactly correct, Malad. Since the time and again, Malad, the letter has been sent to the authorities concerned. neither they are responding nor this is the only things even as of now we don't know about the correct position. However, the direction is given to the deputy commissioner to the finalize everything. That would be fair and fair enough and
I
reasonable.
think so.
Yes,
Even I also think so.
within a period of 2 months or 1 month, my lord.
Yeah, period
Yes.
has to be given, I think
Yes,
so.
yes, my lord. Specific
Categorical
period.
direction will be. Petitioner, the two aspect is there, madam. If the land has to be acquired, compensation is assessed, that can be paid. Then the benefits will also goes to the petitioner. And if they don't want to acquire the land anymore, madam, again land will be given back to the petitioner. So
By giving NOC.
the petitioner is not in.
So if he wants to construct something, he will
Exactly,
construct it.
Yes, yes.
Because it's been 5 years,
Yes.
2018, I think.
2018, the valuation was made, my lord.
Okay.
2012 notification was issued, ma'am.
Yes, that direction, madam.
12 years.
So it's been such a long time.
May I please, Your Lordship?
Yes,
I'm
yes.
preparing for response number 2 and 3.
Hmm.
Your Lordship, there seems to be, there was a request for reassessment of the compensation. Your Lordship. And reassessment was done
It
and
was made.
yes.
Yes, ma'am.
And that valuation has also been given. I
Yes,
think.
ma'am. Yes, ma'am.
To the tune of
The compensation
80.
amount, Your Lordship, we have received was for the was for the assessment made prior to the reassessment, Your Lordship. And after reassessment, Your Lordship, the DC has written to the user agency also, but they are not paying the reassessed amount. Your Lordship.
They are not
This is the-
I think this is the reassessed amount,
Yes, my lord.
an extra 2 series.
Yes, my lord.
But Mr. B. Picha, learned counsel for the petitioner, Mr. M. Kato, learned CGSI for the respondent number,
DSA.
or DS,
DSGI.
DS,
GI.
DSGI, solicitor, DSGIS,
Solicitor.
DSGI.
For respondent number
For
4 to
respondent
7.
number 4 to
7.
7, Miss, Miss
P. Sangeeta,
P. Sangeeta, learned government advocate for respondent number
2 and 3.
2 and 3, and Mr. B. Kamdal, government advocate. Not the Standing Council Land Management Department for respondent number 1,
Your Lordship, I'm government advocate, Your Lordship.
government advocates. I think it went correctly.
Yes, ma'am.
The petitioner has filed his application under Article 226,
Yes, my lord.
226 of the Constitution of India for issuance of a writ of mandamus or any other appropriate writ or direction to the respondents, more particularly respondent number 4 to 7, to take an immediate decision to acquire the land of the petitioner as per by paying compensation as per reassessment valuation report, or issue no objection certificate enabling the petitioner to undertake developmental activities over his own land. It is submitted on, which was the first order when the land was taken for acquisition?
First notification, my lord.
First notification.
Page 28, my lord.
It is submitted on behalf of the petitioner that a notification was issued for acquisition of the petitioner's land.
On 27 September 2012. Page 29 is a type copy, my lord.
Land is petitioner's land at measuring 1404 within bracket 1404 square kilometers located at Kharsa village
Yes, ma'am.
of Jang Circle,
Yes, ma'am.
Tawang district.
Yes, ma'am.
Your Lordship, I'm very sorry, Your Lordship, to interfere, Your Lordship. In paragraph 13 of our affidavit, Your Lordship, there is a statement, according to our instruction, Your Lordship. Since the petitioner, they have they have rejected the compensation amount, Your Lordship. So they did not receive the compensation amount that has been assessed, Your Lordship, prior to reassessment. That is why, Your Lordship, reassessment was made, Your Lordship.
Earlier, they have rejected the compensation and thereafter
Yes,
reassessment was
yes.
made.
And that reassessment amount has been communicated to the user agency, Your Lordship. They are not replying till now.
That reassessment
The
amount has been
situation is-
communicated to you? You are not replying?
Reassessment comes, it is annexed to series.
According to, yes, may I read, Your Lordship? May I read?
Yes,
The-
please read.
Yes, paragraph 13. That we regard the statement made in
Paragraph 13 of your objection?
Yes, Your Lordship. Affidavit. Counter affidavit. The answering respondent begs to state that while.
Respondent number 3?
Yes.
Paragraph?
12.
12. Here I have only respondent number 3. This
Yes, it
affidavit
is
is
for 3, Your Lordship.
only respondent number 3. Paragraph?
Paragraph 13. Your Lordship.
13, yes.
That while this, may I, Your Lordship?
Yes.
That with regard to the statements made in paragraph 14 of the writ petition, the answering respondent begs to state that while disbursement of the compensation of the stretch of BCT road under consideration has already been done, in the case of the petitioner, the same is pending since the petitioner declined to accept the compensation as a compensation received from user agency was as per earlier assessment. One prior to reassessment of his properties, land was done and also currently this office and or DC office Tawang is yet to receive the compensation or any reply on the matter from the user agency with 90 RCC grade.
That is a submission.
It is my submission.
That is
I
his
don't know
submission.
what is this submission.
So
Yes, ma'am.
we are yet to receive any compensation amount.
That is my
regarding
submission.
this, Your Lordship. How
That
do you
is
see?
his submission.
Yes, ma'am.
He has submitted that so far. So
But
far he has
yes.
submitted.
Yes.
To disburse their compensation amount, Your Lordship, therefore, Your Lordship, we have to receive compensation amount from the user agency. Your Lordship.
That is, I'm seeking direction to the respondent of 4 to 7, ma'am.
So that is,
Yeah.
and then it is submitted on behalf of the government,
Yes, ma'am.
that on behalf of UI.
Union.
That a direction may be given, so
Yes,
I
ma'am.
can dispose of the petition with that direction.
Yes, ma'am.
Direction may be given to you, either you pay the compensation or either you give him a no objection certificate,
Yes, ma'am. That much, ma'am. Yes, ma'am.
that much.
It will be proper in the direction is given to the user agency. If user agency need the land, then they will obviously pay the compensation. It will-
Who is the user agency here? You?
4 to
So,
7.
my lord, the fact is, we have not taken position, it seems, my lord.
Yes.
So therefore, my lord, the deputy commissioner, who is the acquiring authority, is the best persons to, my lord, decide everything, my lord. If user agency is not required the land at anymore for the purpose, my lord, then, my lord, automatically the notification will extend, my lord, of course, it has.
My lord, general direction may be given to the respondent authorities.
Say, let us hear you out. He has a point. He doesn't have the land. He has not taken the land.
Yes, ma'am.
So who is the main player here? The
Hello?
DC has to issue a no objection certificate.
Yes, deputy commissioner, my lord. And cancelling the, my lord, notification issued by them, my lord. And
They have not acquired the land
yes, ma'am.
so far.
Yes, ma'am.
Acquired the land to construct the road. It's a road.
Yes,
isn't it?
Yes, road.
Widening of road, my lord.
Hmm?
Then widening of two-lane road. my
Oh,
lord.
widening of road.
My lord, maybe they are looking for the other option, my lord. So because of that reason, my lord. So therefore, my lord, the best, my lord, the authority is deputy commissioner to, my lord, liaise with the user agency, whether they want to acquire the land or not.
Okay, then we will wait for get your instructions in the afternoon. I'll come back and then.
My lord, general direction may be given to all the respondents.
Instruction is not required, ma'am.
Because she is raising objection, that is why I am asking.
My
her.
lord, my lord, the objection is, as per the affidavit is read by her. My lord, is in
That is his
respect of
submission.
earlier position, my lord. They accordingly, my lord, they refused to, my lord, decline to, my lord, they accept the original assessment. Then the representation was
That
submitted,
reassessment
reassessment was done.
done.
In the reassessment, my lord, it seems, my lord, in the assessment, the officer concerned has given his the initial signature also, my lord. After that, several communication has been made to the 90
Yes,
RCC, but no compensation. But now the RCC has to be decided whether the land is required by them or not. That can be done by the deputy commissioner, the acquiring authority. If the user agency is no longer directly, if had it been the case that the case of the petitioner, then he claimed for the compensation as assessed by the deputy commissioner. Then in that case, direction can be given to the user agency 90 RCC for payment of the assessed amount. But here his claim is two
Either
options.
this way or that way.
Yes, my lord.
I'll pass an order either this way or that way. We'll come back at 2.
My lord.
We'll come back at 10. We'll come back at 2.
My lord.
Half order was passed. We'll come back at 2. Let me complete this sentence at least. One sentence I have dictated.
Yeah.
1404, 1,404 square meters located at Kharsa village, Jang circle, Tawang, Arunachal Pradesh. Alright?
Yes, my lord.
Then we'll come back at 2.
Yes, ma'am.
I'm sorry, Your Lordship, otherwise the petitioner's prayer can be allowed.
Allowed.
Yes.
Can be allowed. A tender was floated on, it was, I didn't have declared this line, no? Tender was floated by the respondents on 27/9/2012. Yes.
No, NIT, oh, sorry, notification.
Or notification of.
Notification for acquisition of land.
Yes, no, I have just worked on something relating to tender.
Okay, sir.
The, a notification was issued on 20, did I dictate this order line? No, a notification was issued on 27/9/2012 for acquisition of land by the respondent,
Yes, my lord.
by the respondents, number 3, 4 and 5.
My lord, respondent number 1, my lord.
Respondent number 1
Yes, sir.
for construction of a
Two-lane trans-Arunachal highway, my lord.
for widening,
Yes, my lord.
for widening of Balipara, Chardwar, Tawang Road. The aforementioned land of the petitioner was acquired,
Not acquired, my lord.
Oh.
Assessed, my lord.
was assessed for acquisition.
Yes, my lord.
All right?
Yes.
Was assessed for acquisition by the respondent.
Okay.
Full stop. Thereafter, the order dated 12/8/2018 was issued. All right?
My lord, no, my lord. 12 June 2018, my lord.
Or 12/6/2018 was issued.
Yes. For assessment of land on 26/2018, my lord. Page 32, my lord.
This is the first assessment or reassessment?
This is the reassessment.
Reassessment.
Yes.
After assessment, therefore you cut it out. After assessment, the petitioners did not agree
Yes.
with the
First
value.
assessment.
Huh?
First assessment.
After assessment, the petitioners did not agree with the valuation through the first assessment by the respondents.
Yes, ma'am.
Full stop. Thereafter, the order dated 12/6/2018 was issued for reassessment of the compensation of the land and standing properties in respect of the petitioner for acquisition to construct the proposed BCT road.
Yes.
Annexure 2 is the order dated 12/6/2018. Full stop. The valuation of the land was reassessed in four categories. In 4 categories respectively. Land, comma, standing properties, comma, forest products. More particularly, 4 categories respectively. And horticultural crops. Full stop. The valuation was estimated to rupees 84,39,559. Full stop. The valuation was forwarded to the total. This is the total valuation, no?
Yes, Madam.
The valuation, the reassessed valuation was forwarded to the
Page 33, my lord.
it was forwarded to the petitioner or not?
No, my lord. The officer commanding.
Forwarded to the OC,
Yes, my lord. 90 RCC,
comma, 90 RCC,
which is the requiring authority.
comma, care of 99
APO.
APO.
Yes, sir.
So what did you say?
Who is the requiring authority, madam?
Acquiring.
Yes, sir. Requiring authority. They are in require of the land.
The requiring authority.
Yes.
Stop. The deputy commissioner also while letter dated 11/8/2018 was informed about the reassessment and re-verification.
My lord, date, my lord.
Huh? This page 38?
38.
39?
39, my lord. Yes.
Oh, no, that is the
My
request letter
representation,
from-
my lord. My representation, my lord. To the ADC.
What is this annexure 3?
Annexure 3, my lord. This is the communication, assessment communication to the,
Oh,
from ADC to DC.
okay. The last line you check it out. The assessment communication letter to the from the ADC to the DC is marked as annexure A of the petition. Full stop. After 2018, no steps were taken for acquisition of the land. Then the petitioner filed submitted an application dated 30/12/2019 to the ADC, to the Additional Deputy Commissioner of Jung Subdivision, comma, Tawang,
My lord, for issuance of no NOC, my lord.
for
Issuance of NOC.
apprising him relating to an earlier letter dated 3/12/2019 and seeking issuance of NOC,
Yes.
no objection certificate, as his land has not been acquired since the initial assessment in the year 2012.
Yes.
Since the initial assessment in the year 2012, full stop, the petitioner was unable to renovate his house or to improve
2012 may be cut.
Hmm?
Cut off. 2000, the first assessment was not made in 2012, madam. They have also not specifically mentioned.
Oh,
when.
no. 2018.
Yes, 2018. Yes.
Full stop. Renovate his house or improve his properties.
Yes.
Full stop. Again, on 7 July 2020,
Yes.
another letter was submitted by the petitioner to the Deputy Commissioner Tawang, Tawang District, apprising him about apprising the Deputy Commissioner
Regarding the same grievance.
relating to his grievance about his grievances relating to reassessment, re-verification of his land. He further requested for a no objection certificate to improve his property. July 7, no? This was the letter, 7 July. The letter
Yes.
dated 7 July 2020 is marked as annexure 5 of the petition. The ADC of Jung Division also forwarded the representation of the petitioner to the OC of 90 RCC within bracket GREF bracket close Jung, comma Tawang, stop. Again on 25/10/2022, another representation was forwarded to the ADC.
Was submitted, my lord.
Submitted to the ADC. The petitioner is aggrieved that no steps have been taken by the respondents either to either to acquire his land and pay the compensation or to issue a no objection certificate so that the petitioner can renovate his house and improve his land and property.
Finally, my lord, finally on
Hmm.
25/10, page 46.
Page 46.
Yes, ma'am. Finally, again on 25/10/2000.
I have mentioned, no,
No,
25/10/2022.
No, not measurement. 2022. Yeah. First was on 25/8/2020, my lord. Page 43, my lord. This was forwarded by ADC.
Again on full stop, again on 25/10/2022, another letter, another similar request letter was submitted to the OC
By the
of
ADC.
90 RCC
Yes, my lord.
by the
ADC, my lord.
another representation was submitted. Another representation from the petitioner was submitted by the ADC to the OC 90 RCC graph.
My lord, another communication, my lord. This is the communication.
Another
Communication,
not representation, no?
Communication by the
Communication.
ADC to the officer commanding 90 RCC.
The hard learned counsel Mr. M. Katu has submitted that that has fairly submitted that that a direction can be given to the
Respondent focus.
to the district administration.
And the respondent number 427. Because
To the-
district administration has taken my issue with the
District
Union of
administration,
India. No.
Yes,
It is
we
4 to
have a
7.
role to play.
Union of India, my lord, they have to, my lord, make an approval, my lord, whether they want to acquire the land or not. Yes.
Learned DSGI, Deputy Solicitor General, yes, DSGI, Mr. M. Katu has fairly submitted that that they have not acquired the land.
Yes, my lord.
And
They have not possessed the land, my lord.
no, they have not taken over the land.
Yes,
acquired.
ma'am, yes.
They have not taken possession of the land.
Yes,
Yes. They have not taken possession over the land as this district administration has not acquired the land.
Right.
Has not acquired.
Yes, my lord.
Your lordship, land is
Assessment.
required by the user agency. The respondent number 4 to 7.
Yes, my lord.
And district administration is the only authority to issue NOC. If the user agency,
Which?
user
4 to 7.
agency 4 to 7.
4 to 7, my
4
lord.
to 7.
Yes.
Actually, respondent number 4 to 7 has not taken, as they have not
Have
acquired
not-
the land.
Yes, not, have not paid the compensation, madam, because they have to release the compensation.
Or have not paid the
Then,
compensation.
then only your lordship,
You can,
DC,
Yes,
yes,
because
DC can release.
they have made the assessment and forwarded to the
yes,
Union
yes.
of India.
It is also submitted on behalf of the district administration by the Learned Council, Miss
P. Sangita.
P. Sangita, that the district administration, what was your submission?
After preparation of, assessment,
Ah.
they have, my lord, forwarded it to the Union of India, my lord, the user agency. my lord.
That, yes, they have they have assessed, comma, thereafter reassessed and re-verified the valuation and forwarded to the Union of India.
Yes, particularly.
For payment.
Yes, your lordship.
For
Yes,
payment.
yes, your lordship. Further,
For payment, so that the land, so that the parties may proceed for acquisition of land for the construction of the BTC road.
Yes, ma'am.
Hmm?
Yes, ma'am.
yes, it may be recorded, your lordship, if user agency, they are no more interested in acquiring the land of the petitioner, then they may communicate this to the DC's office, your lordship.
Yes, ma'am.
Up to, so that DC can issue the NOC as prayed by the petitioner.
Respondent
Yes.
number 4.
Yes.
I have considered the submissions at the bar with circumspection. It is true that the land has been assessed and reassessed, and the valuation has been land has been assessed and reassessed, and the valuation has been full stop, assess and reassess, full stop. Thereafter, no steps have been taken for acquisition of the land or for payment of the compensation to the landowner. Full stop. I deem it proper to invoke this extraordinary jurisdiction. Invoke the extraordinary jurisdiction. I deem it considering all aspects, the a direction is given to the respondents number 3 and 4.
4 to 7.
Respondent number 4 to 7 to
communicate the
To
office of
take
DC.
decision.
to take decision if the land is further required for construction of the BTC road,
Yes, ma'am.
and if not, to
Issue NOC.
To communicate in DC's office so that we can issue
to
the-
send a communication to the district administration.
Yes, ma'am.
So that the district administration may
Issue
to enable the district administration to issue a
NOC.
no objection certificate in favor of the petitioner,
Yes, ma'am.
so that the petitioner can renovate his accommodation or renovate his residence or improve his land.
Yes, ma'am.
All right.
Yes, definitely. Within a period, ma'am, 2 months, ma'am.
Within a period of
2 months.
2 months.
Right.
With the above observation, this petition is disposed of.
Right.
No address to cause.
Madam,
Obliged.
obliged.
I'll have to correct it also, no? Yes.
May I please share?
Mm.
Lordship, I am appearing on behalf of the petitioner, Lordship.
Mm.
This matter was supposed to be taken up yesterday, Lordship, but due to my health condition, I could not appear before your Lordship.
Mm.
So this matter has been come up today, Lordship.
Mm.
Lordship, this matter pertains to the junior officer was being sexually harassed at his workplace by the senior officer, Lordship. And consequently, transfer order was issued against the senior officer as well as the aggrieved officer,
Junior.
junior officer, Lordship.
Admission.
Lordship. Pleadings has been completed, Lordship.
Hmm?
pleadings has been completed already, Lordship. So we are praying for disposal of the matter because there's an interim order. I have obtained an interim order from this honorable court, Lordship. If the parties are ready, we can dispose of this matter today itself.
Are you ready?
My lord.
Yes. I'll rise at 2:30 and again I'll come back after some time.
All right,
So you can continue
Lordship,
for 5 minutes at least. I can hear you.
Lordship. Lordship may come to the page number 21, Lordship.
Page number 21.
21, Lordship.
It must be in the other one. WPC. This is an IA.
Yeah, Lordship. I'm in a WPC, Lordship.
Page number 21
Page
of the
number-
WPC.
Yes, Lordship.
Yes.
Lordship. Lordship, this is the first transfer order whereby the respondent authority has transferred me and posted as a DRC, Deputy Residential Commissioner, Lordship, at Mohanbari Airport, Lordship. This order has been filed in the interest of public service following officer are hereby transferred and posted to the district and office as shown, each with immediate effect, Lordship. The serial number 1 is me, Lordship. Missimbi Miri, Lordship.
She is the victim of petition. She's the
Lordship,
petitioner.
I'm the petitioner, Lordship. She is the petitioner, Lordship. Thereafter, Lordship, Lordship, she was being posted as a DRC, Lordship. Consequently, Lordship, on 27/4/2022, Lordship, again another order has been issued so that I can hold the charge of DDO also, Lordship. That is the Rural Disbursement Officer, Lordship. Thereafter, Lordship, in the meantime, what happened, Lordship? The respondent number 5 has appeared, Lordship. On 11/1/2022, Lordship, the respondent number 5 allowed to look after the charge of ARC, Lordship. That is the Additional Residential Commissioner, Lordship.
Respondent number 5 is the
Against whom I have filed a complaint before the authority, Lordship. And thereafter, Lordship, the respondent number 5 started making indecent remarks against me, Lordship, and try to advance sexual advancements also, Lordship. So I being a junior officer, I have avoided him, Lordship. But what happened, Lordship? When the respondent number 5 failed in his motive, Lordship, because I was not reciprocate to his response, Lordship. Thereafter, when he failed in his motive, Lordship, he started harassing me, Lordship, in the office, Lordship, in a daily basis, Lordship.
Now you are in the same office. You are not in the same office.
No, Lordship. There is a stay order, Lordship. I'm still working as a DRC Mohanbari, Lordship. After this petition is being filed before the GR, Lordship. So thereafter, Lordship, the respondent number 5 now he is presently posted at the district headquarters, Lordship, at Naharnagar, Lordship. Since there is a stay order, so I'm still working as a DRC, Lordship. Thereafter, Lordship.
You are still working as a DRC in Mohanbari.
Mohanbari, Lordship.
And respondent number 5 is working as Joint Director at
Naharnagar, headquarter office. On the strength of the stay order only, Lordship, I'm working as a. And thereafter, Lordship, when the respondent number 5 has failed in his attempt, Lordship, he started mentally harassing me, Lordship, by giving all the important works which I was being taken care of, Lordship, as a DRC, Lordship, has been handed over to my junior officer, Lordship. When the entire thing was being avoided by me, Lordship, then, Lordship, what happened? On 5/1/2023, respondent number 5 posted as a JDFSC, that is the Joint Director Food and Civil Supply Officer, ARC, Lordship, permanently in the Mohanbari, Lordship, as my superior officer, Lordship. Thereafter, his action remained the same, Lordship. He sexually harassing me in the office, Lordship.
Mohanbari, respondent number 5.
I beg your pardon, Lordship.
Now he is in Mohanbari.
No, Lordship. Now he is posted at the Naharnagar, Lordship. And thereafter, Lordship, and when there was no other options left to me, Lordship, I have filed a complaint before the authority concerned, Lordship, the higher authority, Lordship.
According to this act, you can.
According to this act. And section 4, by invoking section 4 of this Sexual Harassment of Women at Workplace Prevention and Prohibition and Redressal Act 2013, Lordship. Section 4, Lordship, it provides that internal committee may be constituted, Lordship,
Yes, yes,
headed by the chairman, Lordship.
yes, yes. I think every organization has one internal committee.
Lordship.
So I think this organization also has everywhere in district court, DC court, everywhere they have food and civil supplies. Internal committee they have.
I believe so, Lordship. I think so, Lord. Now, your Lordship will find my complaint. Page number 27, Lordship, Annexure F. This is my complaint, Lordship.
Annexure?
Annexure F,
F.
Lordship, page number 27 of the petition. This,
Just a moment,
Lordship.
Do we have any more cases today? We have. Anybody's waiting for any case? So I'll come
Lots.
after another 10-15 minutes. I'll
Lots.
be back. See, if anybody is waiting, I think there's no point waiting because he will have to complete it.
Right.
You can give them a date if anybody is waiting.
Right.
If we have any case, if anybody is waiting, we won't be able to complete the list today. I don't think so. Because you have a long argument, I think.
Yes, it will take 15 minutes, 15 or 20 minutes, Lordship.
All right, let me come back.
23, Lordship. Yes. As a senior officer, Lordship. ARC, Lordship. Thereafter, Lordship, since the petitioner has not paid any heed to the
Private respondent number 1
respondent number 5, Lordship,
was transferred to Mohanbari.
Mohanbari, Lordship, as ARC, Lordship. Additional residential commissioner, Lordship, which is the
Additional residential
commissioner, Lordship,
commissioner.
Lordship, which is the higher post than the petitioner, Lordship, DRC, Lordship. As I already submitted, Lordship, since the petitioner did not pay any heed to the advancement by the private respondent number 5, Lordship. Now, thereafter, Lordship, and as an act of vengeance, Lordship, Lordship will find at page number 25, Lordship, Annexure D, Lordship. Annexure D, page number 25, Lordship. Here, Lordship, the order was issued by the Lordship.
Page 25.
Page 25, Lordship, Annexure D, Lordship.
Yes.
Lordship. May I read the order, Lordship? Consequent upon joining of Sri so-and-so, that is the private respondent number 5, Lordship, as additional residential commissioner in the Joint Director of Food and Civil Supply additional residential commissioner office, AP Mohanbari, on a regular basis on 3rd April 2023. Being the head of the office as well as the DDO, the charge of DDO of this office will be held by Sri Firoz Modi, that is the respondent number 5, Lordship. This order was issued by the respondent number 5 himself, Lordship, as an act of vengeance, because since I was not reciprocated to advancement shown by the private respondent number 5, Lordship. Lordship. Thereafter, Lordship, since the this DDO, Lordship, was holding by me, Lordship, so I was reluctant to hand it over the charge to the respondent number 5, Lordship. Now the respondent number 5 on next page, Lordship, that is Annexure E, Lordship, has issued an ex parte order, Lordship. Has issued an ex parte order and taken over the charge of DDO from the petitioner, Lordship. Furthermore, Lordship, when the private respondent number 5 was not satisfied with his action, Lordship, he started harassing the petitioner, Lordship, and all the junior officers, Lordship, who were working under him. Well, important official works, day to day, which is being performed day to day routine basis, Lordship, is handed over to the junior officer, my junior officer, Lordship. Now, I am left with no other option, but I have to file a complaint before the director, Lordship. Lordship will find a complaint letter, Lordship.
She was not allowed any work.
Or not, Lordship. I was kept in the dark, Lordship. Page number 27 and 28 is the complaint, Lordship. Lordship will find the type copy at page number 29, Lordship. Annex F, Lordship. I'll not trouble your Lordship with the reading all the content of the complaint, Lordship. This is the complaint, Lordship.
Page?
Page 29, your Lordship will find a type copy, Lordship. The clear and visible one.
Yes.
Lordship. So, Lordship, I will not trouble your Lordship to read all the entire this content of the complaint, Lordship. Basically, it has been reported that the whatever happened after the private respondent number 5 is being posted as a ARC, Lordship, in Mohanbari, Lordship. I was mentally harassed and sexual advancement were daily on a daily basis, Lordship, through the WhatsApp, through the phone, Lordship. It has all has been given in the complaint, Lordship. Accordingly, Lordship, when this intimation later given to the private respondent number 5 by constituted a committee, Lordship, under section 4 of the 2013 Act, Lordship. Annex G is the
When she filed a complaint at page 29.
Lordship.
And then this committee was, internal committee was constituted.
Constituted, Lordship. And thereafter, Lordship, this internal committee, Lordship, is headed by the chairman, Lordship. And Annex G, Lordship, page number 31, Lordship.
Constituted.
Constituted.
Page number 31 is the
Intimation letter to the after complaint was being received from the petitioner, Lordship.
I have seen this office near Mohanbari.
Mohanbari.
Food and Civil Supplies.
Lordship.
Near Mohanbari Airport, I have seen.
Lordship. Thereafter, Lordship, the internal committee and reply has been filed by the private respondent number 5 by denying all the allegations, Lordship, and the meeting has been fixed on 16/6/2023, Lordship.
Internal committee meeting was fixed on 16/6/2023.
23, Lordship. And thereafter,
He has denied the allegation.
yes, Lordship. And thereafter, Lordship, in the meantime, what happened, Lordship, since both the complainant and the accused officer, Lordship, they are posted in the same place, Lordship. Even after filing of the complaint also, Lordship, I was being subjected to the harassment, mental harassment and mental agony, mental trauma every day, Lordship, on a daily basis. And this complaint, this entire facts I have been placed before the committee, Lordship. That is not the Lordship will find page number 34, Lordship.
Page 24 is?
Page number 34, Lordship.
34, yes.
Yes, 34 is the Lordship.
This is the intimation. letter.
Intimation, no, 34 is the Lordship, after the intimation, after the complaint, Lordship.
31, page number 34.
34, Lordship. Page number 34 is I have further intimated the committee that I was being subjected to the mental cruelty as like
In the
before, only,
same
Lordship.
place.
In the same place, Lordship.
This is the repetition.
Lordship.
Repetition of
Repetition,
complaint.
Lordship. Now, Lordship, the imping order part has come, Lordship. Now, thereafter, Lordship, on 31/7/2023, Lordship, since there was so much mental trauma and mental agony, Lordship, I was being faced from the respondent number 5, Lordship, and from the internal committee as well, Lordship. So I have decided to go for a medical checkup, Lordship. Then on 31/7/2023, I was granted a medical leave, Lordship.
31/7/23.
23, I was
Granted medical leave.
medical leave, Lordship. While I was on a medical leave, Lordship, this imping order, Lordship, will find Annexure J, Lordship, page number 36.
Page 36.
Page 36, Lordship.
This interim order was passed.
Yes, Lordship.
So you went on medical leave for how many days?
Lordship, I was on a medical leave only when this order was passed, Lordship.
While on medical leave,
This order has been issued, Lordship. Now, if your Lordship will read may I read the order, Lordship?
Yes, please read.
Lordship. Consequent upon the ongoing inquiry over the alleged sexual harassment case between Srimati so-and-so, DRC Mohanbari as complainant and Sri so-and-so Mohanbari as accused, Lordship. And in order to ensure fair inquiry by the internal committee as investigate in the sexual harassment of women at the workplace, Prevention, Prohibition, Redressal Act 2013. Full stop, Lordship. Para 3 of OM dated, Lordship, number so-and-so, dated 9/9/2016. Transfer and posting arrangement of the following officer with immediate effect are made as follows, Lordship. Now, your Lordship will find the serial number 1, Lordship. That is the respondent number 5, Lordship. He was being transferred to the director headquarters, Lordship, as a same capacity, Lordship. That is Joint Director, Food and Civil Supply Officer.
Mohanbari.
No, Lordship, in Naharlagan. Naharlagan, Lordship.
And this is in Rowing, Dibang Valley.
Like Lordship, I was transferred to the
Remote place.
Dibang Valley, Lordship, Rowing, Lord, as
But
a District Food and Civil
Supply.
Supply.
Capital and she is transferred to a remote place.
Lordship. Now, Lordship, interestingly, Lordship, if your Lordship will see the office memorandum which has been quoted in the transfer order, Lordship, your Lordship will find it page number 38, Lordship. Annex K, Lordship.
Office memorandum.
Yes, Lordship. This office memorandum has been issued by the Central Ministry, Lordship. Lordship. I will not read the entire content, Lordship. Only the paragraph 3, Lordship, which has been quoted in my interim transfer order, Lordship.
Yes.
Yes, Lordship. Further, to ensure fair inquiry, Ministry Department may also consider transfer the suspect officer / charge officer to another office to obviate any risks of that officer using the authority of his office to influence the proceeding of the complaint committee, Lordship. Now, Lordship, the language of this paragraph 3, Lordship, which is being quoted in the transfer order, Lordship, is very clear that it does not even provide remotely, Lordship, the complainant who made a complaint, Lordship, she has to transfer, Lordship. It is the suspected officer, Lordship. The respondent number 5 has to transfer from the place of occurrence, Lordship.
All right.
Lordship. Now, Lordship, this respondent authority, Lordship, not only violate this own office memorandum. May I take your Lordship to the kind attention to the Act of 2013, Lordship. This is a Lordship, the beneficial legislation, Lordship, enacted by the Parliament, Lordship, in order to protect the women at the workplaces, Lordship. Now, Lordship will see the annex, Section 12, Lordship. Section 12 of the 2013 Act.
Yes, Section 12.
Lordship. Action during pendency of inquiry, Lordship. During the pendency of an inquiry on a written request made by the aggrieved woman, the internal committee or the local committee, as a case may be, may recommend to the employer to transfer the aggrieved woman or the respondent to any other workplace, grant leave to the aggrieved woman up to the period of 3 months, grant such other relief to the aggrieved woman as may be prescribed. The leave granted to the aggrieved woman under this shall be in addition to the leave she would be otherwise entitled. On the recommendation of the internal committee, so and so employer. Lordship will see the first stanza, Lordship. During the pendency of the inquiry, only on a written request by the aggrieved woman, Lordship. Until and unless I made a request, Lordship, to transfer me from the place of posting, present place of posting to the another place, Lordship.
But you have a provision for appeal also, no? 18, appeal.
Yes,
Any
Lordship.
person agree from the recommendations made under subsection 2 of section 13 or under clause of subsection or non-implementation of such recommendations.
That is, Lordship, that is the part of the inquiry, Lordship. If the inquiry is found against me or Lordship, if the accused officer is found to be, Lordship, innocent or something, Lordship, then there is a provision, Lordship. Now, so far as the section 12 is concerned, Lordship, this is, since I'm only challenging the impugned transfer order, Lordship, since there is another forum for me to, if I agree by any report, Lordship, of the internal committee, Lordship, I can go for an appeal, Lordship.
Yes.
Now section,
It has to be section 13, 14 or 17,
yes, Lord.
or non-implementation of such recommendations may prefer. Okay,
Only on Lord,
only 14, 13 and 17,
Lordship,
not other sections.
Lordship.
Oh,
Now, Lordship, this section 12, it clearly speaks that only on the request, on written, Lordship, if I made before the authority or internal committee, then,
So you have been transferred.
no, Lordship. That's
But
why,
you
Lordship.
have given a complaint. This is the reason why you were transferred.
That's why, Lordship. That's the exact reason, Lordship. Now, since the inquiry affidavit filed by the respondent number 5 and the government, Lordship, the department, they said that inquiry is completed, Lordship. There is no, they did not found any substantial evidence against the respondent number 5, Lordship. The inquiry is completed. Now, my humble request is before your Lordship is that since the inquiry is completed, Lordship, and entire this transfer order is being issued only on the basis of the complaint which I made before the internal committee, Lordship, the higher authority against the respondent number 5, Lordship. This impugn order has not been issued in a public interest, Lordship. Now that since the inquiry is completed, Lordship, it's already been completed, Lordship. Now my humble prayer is that, Lordship, since the inquiry is completed, this order is no longer, this order has to be set aside, Lordship.
I cannot do anything. I can just consider her stay or something. I can pass an order of this nature only. This is a writ petition, so I cannot give a direction.
Lordship has a power to set aside this transfer order, Lordship. If the authority, Lordship, if the authority,
There has to be illegality.
yes,
There's
Lordship.
Against natural justice, affecting your fundamental rights.
Exactly,
So
Lordship.
and so, so and so.
While I was on medical leave, Lordship, this order was issued behind my back, Lordship. It means the principle of natural justice has been violated, Lordship.
So there are transfer policies also.
Yes, Lord.
So
I am not on that,
it is
Lordship.
not that in your presence that a transfer order has to be issued.
I'm not on that.
The transfer policies, they have their own policies, transfer policies.
Yes, Lordship.
Which are similar, everywhere more or less similar.
Similar.
More or less similar everywhere.
Lordship.
State, government, then autonomous bodies, public sector undertaking, government bodies. Transfer policies are more or less similar everywhere.
Lordship.
So they have their own transfer policies.
Lordship. Now, since Lordship,
But I haven't come across any such transfer policy which includes that on leave you cannot be transferred.
Lordship, if this
And maybe a little bit against natural justice because you are suffering physically and mentally, maybe.
Lordship. Now, Lordship, since the violation of principle of natural justice is the Lordship clearly established in this matter, Lordship. Now, my humble submission is that if this transfer order is issued in a public interest, Lordship, if there is no dispute between the private respondent number 5 and the petitioner, Lordship, this could has been issued by the respondent authority in a public interest, Lordship, in a different manner, Lordship. Not by quoting the para 3 of OM dated 9/9/2016, Lordship, which is clearly speak that only the suspected officer has to be transferred from the place of occurrence, Lordship. Now this order, which is itself is authority, does not have a jurisdiction by invoking this para 3, Lordship. I simply, Lordship, would like to place one judgment, Lordship, in order to facilitate my contention, Lordship. Any order which has been passed by the authority, Lordship, or any forum, Lordship, without having a jurisdiction, Lordship, it's null and void only. Only para 26, Lordship, that small paragraph. I have marked the para 26, Lordship. The said issue, in our opinion, did not attend finality in any view of the matter, Lordship. An order passed without jurisdiction would be nullity, Lordship. It will be a quorum non judice. It is non-ist in the eye of law, Lordship. Principle of res judicata would not apply in such cases also, Lordship. Now, Lordship, since this order dated 7/8/2023, Lordship, has been issued, Lordship, when the suspected officer alone supposed to transfer from the place of occurrence, Lordship, I have been transferred, Lordship, along with him, Lordship. If Lordship set aside this order, Lordship, at this stage, Lordship. The respondent authority has a liberty to transfer me again with the due, with the guideline, by following the established guideline, Lordship.
All right, what do you have to say?
May I, Your Lordship? Your Lordship, in this matters, Your Lordship, petition
You are
contains.
for respondent number 5?
No, Your Lordship, I'm for respondent number.
1 to 4.
Yes, 1 to 4, Your Lordship.
Yes.
Here, your petition contention is that during pendency of the inquiry, the petitioner cannot be transferred out from the present place of posting, Your Lordship, as already the learned advocate has plead before Your Lordship. So, Your Lordship, and this one, Your Lordship, the matter has become infrastructure as Your Lordship, inquiry is over, Your Lordship. As per the inquiry, Your Lordship, there is no sexual harassment against the petitioner, Your Lordship. So, Your Lordship may come to this on page 12, Your Lordship, our affidavit. Page 12, Your Lordship, paragraph 11. May I read, Your Lordship?
Yes, yes.
Here, what happened, Your Lordship? Paragraph 11, Your Lordship. Here, the allegation of sexual harassment of women at workplace, the department had constituted internal complaint committee for fair inquiry of the allegation of the petitioner against respondent number 5. The internal complaint committee headed by Under Secretary and 3 other member of Food and Civil Supply Department submitted report of the internal complaint committee in the matter of sexual harassment complaint by petitioner to respondent number 5 on dated 9/11/2023, white number USFCS/ICC/01/2023. The internal complaint committee, after thorough inquiry, had recommended as under. Your Lordship, due to the inability of the complaint to provide adequate proof to substantiate the claim and the lack of witness to corroborate her statement, the internal complaints committee could not establish the commission of offenses under sexual harassment of women at workplace, as claimed by the complainant's committee, Ms. Simbu Miri, DRC, against the respondent Sri Feroz Modi, Your Lordship. Your Lordship, turn to page 13, Your Lordship. Hence, as per the report, no such offense was committed by the respondent number 5 against the petitioner. Therefore, read petition of the petitioner is liable to be dismissed as her transfer and posting was in accordance to department routine transfer and posting policy, as Roing Dibang Bailey is functioning without regular district food and civil supply officer till today, Your Lordship. And stay order is issued in favor of the petitioners. Ms. Miri need to be vacated by dismissing the petition by this honorable court, Your Lordship.
Yes, yes.
My Lord, my submission will be stand with the government side. Since
You are for respondent 5?
I am for the respondent number 5. So my Lord, what this honorable court has now conceived after the submission of both the government, both the petitioner and the private respondent, all the submission pertaining to the allegation over the sexual harassment at the workplace has now completely not at this stage, because the report has already appeared before the committee report has already been placed before this honorable court, whereby it is said that he could not, the petitioner failed to establish the allegation. So that is the part person. Therefore, whatever the allegation on the basis of that harassment in the workplace is completely invalid. Secondly, my Lord, the ground which could be what I can say the last oxygen line of the petitioner to establish the case that whether the impugn order issued, the impugn order before the Lordship is issued by the respondent number 5 or not. So far the submission of the petitioner is concerned, this has been issued by the, not issued by the authority, but issued by the respondent number 5, which is completely mistake. What I can say, because the record is clear, record is before the lordship, that this has been issued by the authority, not by the respondent number 5.
Said authority only.
Yes,
And
he said authority.
yes,
The first order was issued by respondent number 5. He has taken the charge as DDO.
they are
He has
all,
taken her files.
my lord. They
That
are
was
also,
issued by him.
if my lord, if we go to the column, my lord, that has not been signed by. That order is prepared in the office, officially that is prepared by their staff, and that has to go through me. Therefore, the name of the respondent number 5 is reflected there, but not the authority, these signatories. Signatories is the, my lord, director. It's itself in the, my lord. The record itself is speaking, my lord. Is very clear. That is also wrong. Now, lastly, my lord, what was the other ground is that this was issued while she was on medical leave. Therefore, this court need to ascertain that without producing the record, whether he was on the medical leave or not, without any record claiming on the oral submission that she was on the medical, so this was issued. And one thing is to be assumed that even if this was issued when she was on the medical leave, how she come to know that this order, impugn order was passed, and accordingly he come forward for challenge my. There, and my lord, because my lord, this already everything come up, therefore I shorten up my argument, my lord. In this point only. Now, my lord, in such situation, the last ground is that this transport was not issued on the public interest. To that aspect, my lord, I can go with her also, because this transport was not, this was created by herself. In fact, the truth which to be revealed before this honorable court is that she was transferred on 2021. In due course of the time, the power which she hold was the DRC CAM, ADRC, Additional Deputy Residential CAM Joint Director, was taken away by the order dated 21/4/2023, which is in my lord record. Thereafter, petitioner realized. Then the first complaint of the petitioner has appeared in the, my lord, that we have gone through in page 30 on 1st May 2023, alleging that since 2021, this person has harassing me in the office, my lord. Now she remember when therefore, my lord, the truth is the facts, the gospel truth in this case is the bone of the contention is who will be the joint director of Food and Civil Supplies, CAM, ADRC, and the Mahanbari. When in subsequent proceeding,
have you mentioned this in your affidavit?
Everything is mentioned in my affidavit in opposition. So troubling started, my lord. How this can be, my lord, believe that she has been harassing me since 2021, and now that complaint come on to the 2023, my lord. And so far, my lord, this I will not press on this particular pertaining to this harassment, my lord, since the committee has found. Therefore, at this stage, the case has totally, my lord, case become infectious. Because whatever the submission by the petitioner is purely, my lord, that during the pendency proceeding of the committee, she cannot transfer. That, my lord, I can agree with her. As per the section 12 of this, my lord, the harassment in the workplace. But for that, she already stayed the interim order. Therefore, during pendency of the during proceeding of the entire episode of this committee, she was there, but I have been posted. Therefore, this transfer order. But now, out of this transfer order, who is harassing? My lord, I am harassing. I am the person supposed to be discharge my duty at Mahanbari. But on the basis of the, now I can confidently say that because of this false complaint, I have been transferred. Therefore, my
To the
lord,
capital complex.
see,
Naharlagun.
yes, I am at the Naharlagun. Now,
When you are transferred to from Mohanbari, such a little
Mohanbari.
place to capital complex, how you are harassed?
I am at the Mohanbari, I am at the Mahalaja, Naharlagun. I am the person who deserves
Okay,
to
let
be
me start with
over.
it. I don't know how I end. Let
My-
me start with it. You'll be available tomorrow, day after tomorrow also?
Lord, sir.
You all are here, day
My lord.
tomorrow, day after tomorrow?
Ma-
So we'll start with the petition and then let's see
Lord,
how
sir.
it ends.
Lord, sir, it's small reply to the submission.
You will reply
advance.
tomorrow, day after tomorrow.
Oh.
You'll reply. Reply is reserved. I cannot take in so much.
Lord, sir.
Morning one argument of 100,302. Then again I took up one argument,
Oh, I
and
can
passed
understand.
one order.
So tomorrow, day after,
Just now.
let
Yes,
This
sir.
afternoon I passed one order, WPC.
Or Lordship may go peruse the entire.
You will reply.
Lordship.
I'm here for 2 weeks.
Lordship.
Now I will start with the petition. I'll dictate. You'll help me out.
Let us fix the date.
No, no,
No,
no.
no. You will reply. If I can finish, then I'll finish it.
Uh-huh. If your Lordship will reserve the
You'll
order also,
reply,
Lordship.
No, I
will
won't.
fine.
No, I won't reserve. I cannot carry so much of luggage in my bag while
All right.
going back.
It's only small reply. It will take 5 minutes only or 2 minutes only.
You will reply later.
Okay.
It's already 3:30.
All right.
You'll reply. I'll take in your reply.
Okay.
I'll first dictate the petition and the WS.
Okay.
Reply reserved.
No. This will be, my lord, this will be treated as part heart.
No, I'm just noting it down. Reply reserved. I'll not dictate out entire petition. IAs will be disposed along with the petition. You have an IA also, no?
Yes.
It will be disposed along with the petition. And meanwhile, if you have judgments, you can furnish judgments. Hard, Mr.
Tigaram, Lordship. Tigaram,
This is WPC, no?
Lordship.
Judgment and order liquid. Hard, Mr.
Tigaram, Lordship.
Item number 30.
13 is the IA, Lordship. Is IA filed by the private respondent number 5 for the vacation of the interim order, Lordship? That IA is become infractious, Lordship. Lordship.
Now we will finish this together.
Yeah, Lordship.
30 was no item number?
Yes, Lordship. 13 and 14, Lordship.
13 and 14.
Lordship.
G. Tara?
Tigaram, Lordship.
T. Garam.
Lordship.
Heard Mr. T. Garam, learned counsel for the petitioner. X, within bracket name withheld. Full stop. Heard Miss
P. Pangu, your Lordship.
P.
Pangu.
Government advocate, Lordship.
Your name is not recorded, no?
Lordship.
It's P. Pangu.
Yes, your Lordship.
Learned
Government.
advocate. Oh, okay, that's why your name is not available. For respondent number?
1 to 4, your Lordship.
1, 2, and 4. 1, 2, 3, and 4.
Yes.
And
C Modi for respondent number 5.
C. Modi, learned counsel for respondent number 5. The petitioner is an employee under the which is what is the department?
Food and civil supply laws.
Under the food and civil supplies. Presently posted at Mohanbari.
Lordship.
Presently posted at Mohanbari. Full stop. The state of Arunachal Pradesh, number 2, the director, comma, food and civil supplies, comma, the joint director, food and civil supplies, come additional resident commissioner, comma, the internal complaints committee of the same department are arrayed as respondent number 1, 2, 3, and 4. And the so private respondent Sri Firoz Modi is represented by. I've given you name, no?
Yes.
C. Modi.
Oh, I
C.
already
Modi.
given Nalai to cut it here. Others will be left over. I'm dictating an order.
Before that, madam, I was in this matter.
Oh, you were in this matter.
Yes.
You have any submissions done? It is continuing. I'm just passing an order.
My lord.
Then it will continue till 2-3 days. I'll complete it within 2-3 days.
My lord.
So within these days, you are here very much
I'll,
here.
I'll be here, my lord.
Okay.
Yes,
The
madam.
part submission is reserved.
My lord.
I'll hear you out.
My lord.
The petitioner has filed and keep asking. Oh no. I'm dictating the order till 4. Then we'll spill over to the next date. The petitioner has filed an application under Article 226 of the Constitution of India for issuance of a writ in the nature of certiorari, mandamus or any other appropriate writ. Rule has been issued? No. No. Rule has not been issued.
Your lordship is disposing the matter or making a part hard or my lord?
Part hard.
Part hard, my lord.
But I'll carry on with the dictation.
Okay. But our submission is very clear, my lord. As per that act, my lord, based on that act, the honorable interpret with the transfer order. We have not raised objection because inquiry was pending. That is only the crux of the matter, my lord. Since now inquiry is completed and inquiry report, my lord, found nothing wrong, my lord. So matter become infractious, my lord.
That has been
My lord.
submitted.
Yes.
My reply is pending, lordship, to that effect, lordship.
With a direction or to set aside and quash the impugned order of transfer dated 7/8/2023, whereby the petitioner was transferred from Mohanbari to Rowing.
Rowing, lordship.
Stop. By order of transfer dated 11/8/2021, the petitioner was posted as DRC at Mohanbari. And she was also in charge as the drawing and disbursement officer within bracket DDO bracket close. By order dated 27/4/2022. Full stop. In the meanwhile, the respondent number 5 by order of transfer dated 11/1/2022 took charge of office as Joint Director of Food and Civil Supplies, additional resident commissioner within bracket JDFCS. Nalage. Within bracket ARC for short, bracket close. At Mohanbari. It is next paragraph. It is averred by the petitioner that there is respondent number 5 made several inappropriate advances towards the petitioner. Full stop. The petitioner tried to avoid the advances but finally tried to avoid the petitioner avoided the advances. Full stop. However, comma, to wreak vengeance, the respondent who was unsuccessful in his pursuit to exercise in his pursuit to harass the petitioner stopped allotting any work to the petitioner. Most of works were assigned to the to the employees who were junior to the petitioner. Which resulted in the mental agony which resulted in immense mental agony of the petitioner. The petitioner was hesitant to proceed with any formal complaint against the respondent number 5, who was her senior. Void order dated next paragraph. It is further contended that void order dated 21/4/2023, the petitioner was directed to hand over the charge of the DDO to the respondent number 5. To avenge the resistance of the resistance to by the petitioner of his indecent advances. Full stop. The order was issued with malafide as the order was issued with malafide intent, the petitioner did not hand over the charge of DDO but void order dated 26/4/2023, the respondent number 5 through an ex parte order took over charge from the petitioner as DDO. Full stop. Annexure D and E are the orders dated 21/4/23 and 26/4/2023. It is further contended that that as the respondent number 5 ceaselessly pursued with his indecent proposals, the petitioner who was suffering from such harassment filed a complaint before the Internal Complaints Committee constituted under Section 4 of the Sexual Harassment of Women at Workplace within bracket Prevention, Prohibition and Redressal bracket close Act, 2013 within bracket herein after referred to as the Act of 2013 bracket close full stop. The said committee intimated the respondent number 5 regarding the complaint filed by the petitioner on 25/5/2023 within bracket annexure G bracket close. A meeting was held and the inquiry was conducted as the petitioner did not reciprocate towards the advances to the advances made by the respondent number 5. She was kept out of important official work. So meanwhile, the petitioner took medical leave and was granted leave while order dated 31/7/2023. Full stop. Surprisingly, while the petitioner was still on leave from the respondent authorities, issued the impugned order dated 7/8/2023, through which the petitioner was transferred from Mohanbari to Lower Dibang Valley, rowing as District Food and Civil Supplies Officer, and the respondent number 5 was transferred from Mohanbari to the headquarters at Naharlagun. This is annexure. Huh?
Annexure J, Lordship.
Annexure J, within bracket annexure J.
Page number 36.
Next prayer likha. The petitioner has prayed for it is contended that the order of transfer was illegally and arbitrarily passed and is violative of the OM dated 9/9/2016, which is marked as annexure.
K, Lordship.
Which is marked as annexure K of the petition.
Lordship.
Page 58 or 38.
Annexure K
38,
is
no?
Lordship, page 38.
Page 38. To page 38 of tumi jaba. The মই দেখুৱাই দিম কোনটো লিখিব লাগে। The learned counsel for the petitioner has submitted that the annexure K, that is the OM dated 9/9/2016, clearly reflects that within inverted commas এইটো হেৰি para 3 টো লিখি দিবা টিক মাৰ্ক দি থা অকল para 3 টো লিখি দিলে হৈ যাব but it is also submitted by the learned counsel of the petitioner that the impugned action is also in violation of the Act of 2013 or Section 12 of the Act of 2013. Section 12 of the Act of 2013, which provides that during the pendency of an inquiry, on a written request made by full stop DDR. That is it, that para 3. The impugned action is also in violation of the rights of the petitioner guaranteed by Articles 14 and 16 of the Constitution of India. And there is no bar Thus, this court can grant or this court can exercise its extraordinary powers under Article 226 of the Constitution of India. The petitioner's order of transfer has been stayed by this court, right order dated. The first order,
Yes, Lordship. 21/9/2023.
and the petitioner is at present posted at Mohanbari. It is further prayed by the petitioner. It is thus prayed by the petitioner that the petitioner that the impugned order of transfer dated 7/8/2023 be quashed and set aside. So we'll continue. Heard Mr. এতিয়া এটু কৈ থৈ দিবা এতিয়া এনেকে লিখি দিবা হাৰ্ড মিষ্টাৰ এখেতসকলৰ নাম লিখি দিবা আগতে লিখাই আছে কাইলৈ নালাগে এইটো পৰহিলে কৈ দিবা কাইলৈ আৰু এটা আছে নহয় day after tomorrow
Lordship.
You'll be present day after tomorrow then you can submit your part and your reply.
Lordship.
You want to who wanted to reply?
Me,
You
Lordship.
wanted to reply,
Lordship.
yes.
It will only take 5 minutes, Lordship.
Yes, yes. We'll conclude day after tomorrow.
Lordship.
If not, then maybe Monday. Suddenly I remember day after tomorrow I'll proceed to Lakhimpur Court for inspection.
Lordship.
Suddenly I remember. Day after tomorrow, then if not day after tomorrow, then Monday.
Lordship.
Day after tomorrow.